Good morning, everyone. Welcome to the Joint Standing Committee on the Judiciary. I'm going to give our colleague who just had to step out for a moment a minute to return. I do want to make an announcement before we get started today, which is that one item on our agenda for this afternoon, LD 1911, is going to be postponed and rescheduled for a later date. And that notice is going out to interested persons. So or interested parties. Thank you. And so just again, 1911 scheduled for a work session this afternoon at 1 is going to be postponed and rescheduled. Okay, let's. And this morning's work sessions, we're going to do them in the order they're listed: 2120, 2163, and 2059. And so with that, Representative Sinclair, could you please start us off with our introductions?
Good morning, folks. My name is David Sinclair. I'm here for the people of House District 50, which is the city of Bath.
Good morning, everyone. I'm Dylan Pugh. I represent House District 114, which is part of Portland.
Good morning. I'm Danny O'Halloran, and I represent the good people of District 20, which is the industrious city of Brewer.
Good morning. My name is Mark Babin. I represent House District 3, Northeast Aroostook County.
Hello, I'm Adam Lee. I represent House District 89, which is downtown and New Auburn.
Good morning. I'm Amy Kuhn. I represent House District 111 in the town of Falmouth, and I serve as the House Chair of the committee.
My name is Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, and some of Scarborough, and I serve as the Senate Chair. I did want to let everyone know that committee members are very busy with various bills and other committee work in other committees, and so you'll notice that we are in and out today. So please don't interpret that as us not being focused on your bill. We certainly are. And at this point, I also wanted to note that we're joined by OPLA analyst Janet Stocco and committee clerk Susan Panett. And with that, we'll begin our first work session. So we're opening the work session on LD 2120, an act to enable survivors of abuse to disable connected vehicle services.
So this bill would allow a survivor of certain crimes to request that a motor vehicle manufacturer, its affiliate, or its agent terminate or disable the access of an abuser to a connected vehicle service. So helpful definitions in the bill are that a survivor is defined as an adult against whom one of the following acts either has been committed or allegedly committed. It includes certain crimes under the Violence Against Women Act, certain crimes described in the Federal Trafficking Victims Protection Act of 2000, and then similar acts under state, tribal, or federal law. It also specifically provides that a criminal conviction is not required for a person to be considered a survivor under the bill. Abuser is defined in the bill as the individual identified by the survivor as having committed or allegedly committing the crime. And then a connected vehicle service is a capability that enables a person to remotely, either through a mobile device or a computer, obtain data from or send commands to the vehicle. So the bill establishes a procedure for a survivor to make these requests from the manufacturer. So to do that, the survivor must include the vehicle identification number, the name of the abuser, and one of the following: either proof that the survivor solely owns the vehicle, or proof that the survivor exclusively legally possesses the vehicle, for example, through a court order awarding sole possession of the vehicle to the survivor, or if the vehicle is owned in whole or in part by the abuser, a divorce decree or other type of order, like from a protection order process that names the abuser and either grants the survivor sole possession of the vehicle or specifically restricts the abuser's access to the connected vehicle service data. Once the request is received, within 2 business days, the manufacturer must do one of the following, which I'm going to tell you, and then also must deny any request from the abuser for subsequently generated connected vehicle services data. So in addition to denying the abuser's request for that data, the manufacturer must either terminate or disable the abuser's connected vehicle services account for that vehicle, or terminate or disable the entire connected vehicle services account, clearing all its data and instructing the survivor either how to reestablish the connected vehicle services generally or how to reestablish it without access by the abuser, or inform the survivor how to, I shouldn't say determine, is disable the connected vehicle services using an in-vehicle option. So other things to know about the bill is there is an exception if the manufacturer can't operationally or technically effectuate the request. They don't have to follow through, but they must promptly notify the survivor of that issue and any steps the survivor can take to assist in remedying that problem. The manufacturer is also prohibited from charging a fee for following through on the request or conditioning its response based on the approval of the action by someone who's not the survivor, or an extension of the connected vehicle services account, or an increased rate of payment for that account. There are certain notices the bill requires, so the manufacturer must include information on its publicly accessible website on how survivors can make these requests. Manufacturers must also automatically send a notification email to the survivor who submits a request and after taking action in response to the request. But if the abuser still has access to the survivor's email, they can request that that email account not be used, and the manufacturer has to allow the survivor to pick another contact option. In addition, if the manufacturer is going to notify the abuser of the action it took in response to the request, it must forewarn the survivor by at least 3 days. The bill also provides that the manufacturer has to treat the information submitted by the survivor as confidential and also dispose of the information within 90 days, except it can retain that information for a longer period of time if it's reasonably necessary and proportionate to verify that the request was filed correctly. In addition, unless required to respond to the survivor's request, the manufacturer may not share the information that was submitted with a third party without the survivor's consent. The bill also provides the manufacturer, its affiliates, its agents, officers, employees, etc., that they are immune from any claims, quote, deriving from an act or omission with respect to compliance with this chapter, end quote. And then finally, the bill requires a survivor to take reasonable steps to notify the manufacturer if there's been a change in ownership or possession of the vehicle that would materially impact the manufacturer's duties under this law. So some issues for consideration that were raised in the public hearing were what proof of ownership or possession of the vehicle should be required for a survivor to make a request under this legislation. And I just restated here the types of proof the bill as currently drafted requires. And there were some proposals from the Maine Coalition to End Domestic Violence that I'll talk about in a minute for maybe changing the approach in the bill. There were also questions at the public hearing about law enforcement access to location information. So as drafted, the bill authorizes the manufacturer either to limit only the abuser's access to this information or to completely shut off the services, including location data for the vehicle. And so some committee members were concerned that if these services are completely shut off, will that inhibit law enforcement from using these services to find the survivor in an emergency? And I did want to say that presumably, I don't actually know if my car has this service. I don't know for sure, but presumably the person who owns the car may already request that these services be discontinued or disabled, regardless of whether they're a survivor. So that concern may exist in the real world anyway. But I did want to remind you that if the person driving the vehicle possesses a cell phone, current state law authorizes law enforcement to access the cell phone location information in emergency circumstances, and I've attached the laws governing that. And those laws say that generally law enforcement has to have a search warrant before obtaining location information for an electronic device. But if there's no federal law prohibiting it, the law enforcement agency can obtain this information without a warrant to respond to a user's call for emergency services with the informed consent of the owner unless the device is legally possessed by someone else, with the informed consent of the guardian or next of kin. If the owner or user is believed to be deceased or is reported missing and can't be contacted, or if the law enforcement agency reasonably believes that an emergency involving imminent danger of death or serious physical injury to a person requires the disclosure. So again, this is about location access to location information from an electronic device. I attached the law. I don't know if that electronic device could be interpreted to include a car itself that has this telematics information, but at least the phone. And we've talked a lot here about how phones are basically glued to people's hands at all times. But might not be in an emergency if someone's running away. I concede. As far as proposed amendments, the sponsor did testify that she plans to work with victim advocates to propose an amendment addressing their concerns. And just to remind you of the concerns in the testimony from the Maine Coalition to End Domestic Violence, they did suggest altering what I talked about earlier, the possession or ownership requirements about who could make a request, what type of ownership or possession is required. So the bill kind of requires both that the person is a survivor and allegedly or has been found to be a victim of certain crimes, and that they have certain amounts of possession of the vehicle. And the coalition proposed viewing those as separate approaches. So you could allow this a person to request that the services be disconnected if they can demonstrate sole ownership or sole legal possession of the vehicle. It shouldn't also require that they be a survivor of certain crimes. Or if the requester is a survivor of certain types of crimes and has legal possession of the vehicle, then they could be allowed to make the request. And as far as showing legal possession, one example from New York is showing that the survivor is married to the person when the car is purchased. And in addition, New York also has language in their law saying that the Bureau of Motor Vehicles in that state can determine what proofs qualify to demonstrate the survivor's possession of the vehicle. So if it's just sole ownership or sole legal possession, you shouldn't also have to prove you're a survivor, according to the coalition. But if you do want to expand it beyond sole ownership or sole legal possession, maybe having both the survivor of a certain crime and some type of proof of legal possession. They also suggested that the bill require manufacturers to include a mechanism in every vehicle that allows the connected vehicle services to be disconnected immediately by the driver. And they noted that California imposed that requirement effective January 1st next year. They also suggested that the definition of a covered act, which under the current bill before you refers to several federal laws, definitions of crimes, or similar state laws. They suggested just following the state law definitions of these types of crimes that are considered domestic violence in Maine, because those crimes are well understood by law enforcement and advocates. They also said that, or suggested that the way the bill is written now, it is possible that someone who we would consider the perpetrator in the situation might be able to use the bill to their advantage and turn off the survivor, in our opinions, access to the connected vehicle information. And one way that this is emphasized in the bill is the definition of abuser. And so it might make sense if you're going to require if you're going to permit survivors of certain crimes who maybe have a lesser ownership interest in a car to get the services disconnected, that maybe you should require some type of attestation from the victim that they are the victim of a qualifying crime. And that could be either their own affidavit or some kind of letter of support from an advocate or law enforcement or a doctor, as some kind of proof beyond just I asked the motor vehicle manufacturer to turn it off and made this claim. They also thought that there's a provision in the bill that talks about the manufacturer not having to follow the timelines if there's an emergency situation, and they thought that that could be strengthened to require more immediate responses in emergency situations. They also pointed out that the bill should not require notice to abuser that the survivor's request has been granted unless the abuser is at least a co-owner of the vehicle. I should say that I think I read the bill differently than other people do. I don't read the bill as requiring the manufacturer to notify the abuser in any situation. I just read it as requiring them to notify the survivor 3 days before they notify the abuser, if they do. But if that is viewed as mandatory, that's something to consider whether you're comfortable with that or not. And then they also had some comments about the manufacturer immunity provision and asked that you consider insulating manufacturers from liability only for good faith actions as opposed to actions involving willful or reckless misconduct or gross negligence. Because as the immunity provision is written, if a manufacturer just didn't do anything at all, it looks like they would be immunized from suit because it's taking any acts or not taking any acts about compliance with this section, not if you're following the section, if that makes sense. They also suggested you consider penalties for manufacturers who violate the law's deadlines. Yesterday, we received testimony online from the Truck and Engine Manufacturers Association, who suggested that you consider taking all commercial vehicles out of the scope of this law, because often commercial vehicles and commercial vehicle fleets, they need to know where all their trucks are. They had suggested doing that by only including a car or light duty vehicle in the definition of covered vehicle. An alternative approach would just be to not include a commercial vehicle or only a vehicle for personal or household use or something like that. And probably I suggested that because I don't know how to describe a light duty vehicle, but I can figure it out if you want me to. And then you had several requests to different folks, including asking about how the bill interacts with law enforcement requests for vehicle locations in emergency situations. I did provide a little bit of answer, but mostly about cell phones, if the survivor has the cell phone with them. You asked about other states, and I did attach the laws from California and New York because those were the ones specifically referenced in the Coalition to End Domestic Violence's testimony, although I did forward you their email, which does contain links to the Louisiana and Connecticut laws as well. And I did want to point out that there is a nearly identical bill before Congress right now. It's gotten to the stage of being referred to committee last year, and I haven't seen any further action on it. You also asked if there are contracts in which banks, credit unions, or other lenders provide financing for purchasing the vehicle, require that the connected vehicle services be operational as a loan condition. And I did attach some responses from a contact from the Maine Credit Union League, as well as the lobbyist for the Maine Bankers Association. And there is a gentleman, I believe, on Zoom who's available to talk to you about the fact that they don't believe this type of loan condition is common outside of the buy here, pay here lending environment, of which I know very little other than it's a lending environment that's more accessible to folks with bad credit, which may in fact include some of these survivors who may be subject to economic abuse by the perpetrator and thus have bad credit. As far as insurance contracts, folks asked if insurance contracts for motor vehicles include as a condition of coverage that these connected vehicle services remain active. And I contacted the Bureau of Insurance, and they indicated that the use of telematics is generally not a condition of coverage, but it may be a way to get a premium discount if you allow some telematics. But those premium discounts don't rely on you having telematics in your car. There are other devices you can put in the car or other ways to get that telematic information to the insurance company and give you the discount. So you don't have to use the connected vehicle services themselves, is my understanding from their response.
Thank you very much, Janet. Committee members, before we start with questions for Janet, Representative Caruso and Representative Henderson, would you like to introduce yourselves?
Thank you, Madam Chair. Good morning, everyone. I'm Elizabeth Caruso. I represent people of House District 72, which is much of northern Somerset County.
Good morning, everyone. I'm Rachel Henderson. I represent the people of House District 78, which are the beautiful towns of Bethel, Byron, Hanover, Milton, Roxbury, and Rumford.
Thank you both. Committee members, are there questions for Janet? Representative Lee?
Curious how we would be able to distinguish between those. So the suggestion by the Commercial Drivers Association, for instance. How would you be able to distinguish, or how would the dealer be able to distinguish between the uses of their vehicles? For instance, someone could have a commercial vehicle that's purchased, that's just the same as their own vehicle, but their use and their registration of the vehicle is what determines.
And that may
It's
be why
different.
they suggested actually talking about the type of vehicle rather than the use of it. And if that's true, then I'm happy to work with folks who can help define that in a way that you're comfortable with. I do know that other laws include for personal and household use, but you're right, that maybe would have to be in the attestation
Yeah.
if there is one.
Any other questions, committee members? Yes, Representative O'Halloran?
My question is around the commercial, like, let's say you have a maid service or you paint houses and it's used for business. Would they, and say that the victim is part owner or maybe not the owner, but she's the one that is doing that service? How does that affect this in this bill? When you
So-
think commercial, is it just big commercial?
So the bill right now doesn't have any exceptions for any type of vehicle. A manufacturer would have to respond if you were to enact it as written to any request. But the survivor would have to show some type of legal possession. Remembering now the
Yeah, I saw
proposed
that.
change, but if we look on page 4 at the top, one of the following: sole ownership, proof of exclusive legal possession, which might be from a court order, or if it's owned in part by the abuser, some type of court order granting them possession. So that probably wouldn't apply. Except maybe, well, I don't think their legal possession would be exclusive. It's if it's sort of like a company vehicle. So I don't think it would qualify under any of those three. But there isn't any exception currently written about commercial vehicles. So let's just say it's their own company
Yeah, that's what I was trying to say.
and they own the vehicle as well through owning the company. Right now, that would be covered. If you want to craft some type of exception so that if it's a commercial truck or something, interstate truck driver where the company needs to know where that vehicle is at all times, then we'd need to be careful to make sure we don't include things you don't want to include.
Mhm. Thank you.
Additional questions, committee members? For Janet? Is there any committee member who has a question for someone other than Janet? I actually have a question for you, Representative Boone, to put you on the spot, but have you been reflecting on privacy legislation and how this does or doesn't dovetail with the existing privacy legislation that's pending in the House? I'm sorry to put you on the spot.
That's okay. Well, geolocation data would be classified as sensitive data so that it wouldn't be available for sale under 1822, the majority report. If it's being used simply within this platform that the consumer wants to use it in, then I think that would not be applicable. It really relates to the sale and transfer. I do have a
Thank you,
question.
and then I'll call on you as well for your question.
So I was curious, we heard some testimony at the public hearing that this is one version of this type of bill, but that there are stronger versions of this type of bill in other states that are more protective or more survivor focused. And I'm wondering if we could have one of the advocates come up and just talk about that. Am I remembering that correctly? And what is?
They did reference both California and New York, which those are attached in purple. And then there's a summary from the International Association of Privacy Professionals on top, because it goes through, it summarized them much more briefly, probably more helpfully than I would have if I tried. So, but they may have, like the Louisiana or Connecticut ones, better Those were just my guesses.
Thank you. And I see Andrea Mancuso is here in the committee room. Are you able to address this question?
Good morning, Andrea Mancuso from the Maine Coalition to End Domestic Violence. I think your questions were which of the other states' laws do we think are better? So I think Janet has done a fabulous, I think, job of pulling together the relevant information for you and summarizing where we think you should take things from the other laws. In my mind, the best policy approach is actually to take both California's law and New York's law and sort of put them together, because California takes the approach where though they understand their law is going to be responsive to this issue for survivors, they have set out a law that says if you can establish sole ownership or exclusive possession, anybody who meets that standard can ask for the services to be terminated. New York has taken an approach from my review of what they've done and talking to their coalition that is survivor focused. And because it's survivor focused, they are saying if you can prove if you can attest you're a survivor, then you can shut off these remote relaying of information from the vehicle if you can establish legal possession, as opposed to exclusive legal possession or sole ownership. And so that's the example that Janet noted in their law around if you were married to the owner of the car at the time the car is purchased, that would demonstrate that you have a legal possessory interest in the car. And if you can attest that you're a survivor, then we'll allow you to cut off the abuser's ability to see where the car is remotely. So I think both of those two are very good policy approaches. And it seems to me like there's benefit in entertaining both of them for the broader public, allowing the broader public to cut it off. And also,
Did you have any follow-up?
Thank you.
So I have one follow-up for you. I'm thinking back to like the basis for getting a protection from abuse or protection from harassment order under Maine law. And the ability of anyone who is the sole possessor to discontinue these services would actually be a way to prevent some anticipated harm. Is that correct? So you wouldn't have to wait until the harm had happened
yes.
in order to get the protection.
Yes, I think you're right in that. And I think that's the approach that California has taken.
Thank you. Other questions for Andrea Mancuso? Representative Lee?
Yeah.
Oh,
I think I'm stuck back at a question that I asked at the public hearing, and I don't remember the answer to it, and I don't remember if there was an answer to it. I don't understand why the car manufacturers need this law in order to do what is prescribed in the law. I don't know if that's a question for you.
So I guess I don't understand why they need this law either, but it appears they do in order to give people the right to cut off this access.
So it looks like someone.
Attorney Fraser might have the answer to that question.
Thank you very much. Representative Henderson, did you have a question for Andrea Mancuso? Then let's take that question and then we'll move on.
Sorry. It's okay. Good morning.
Good morning.
Is it your anticipation that the car manufacturers and tech support would be the ones determining all these fact patterns on whose possession, who's not possession, what's determined credible?
I mean, I think that that's what the law in New York and California require at this point, right? Is that you have to submit some level of documentation. California's, they both require some level of documentation as to ownership or possession. California's does not require that you attest to any sort of harm or risk of harm against you, because theirs is just the broad if you own or have possession of the car exclusively, you have a right to this thing. New York's does, I think, contemplate that there is some level of evaluation. Survivors are fairly used to certifying the risk of harm to them in other contexts, in housing and the protection from abuse context. I don't know if that answers your question, but yes, I mean, I can't sit here and tell you how they would do it on the back end, but California is the single greatest consumer market driver around vehicle purchases in the country. And I think New York's sitting at number 4. So I think the car manufacturers are figuring out how to do this. I've seen some websites for car manufacturers that actually lay out sort of a grid that says, how do you disable what's your rights for disabling these services? If you're in California, click this tab. If you're in New York, click this tab. If you're in any other state, click this tab. And then it just sort of lays out how a person would do it. So I think they're figuring it out.
Any other questions for Andrea Mancuso? Seeing none, thank you. Yes, if you could please join us and answer on behalf of the car dealers.
Good morning. My name is Elizabeth Frazier, and I am here on behalf of the auto manufacturers. I am happy to provide an answer to your question representatively. I believe that the answer is in cases, it is necessary in cases where the survivor is not the vehicle owner, the sole owner. So if you're the sole owner, I don't believe there would be any prohibition in you reaching out to your, to the vehicle manufacturer and saying, I don't want these features or services. Can you shut them off? This is to get at the issue of like a family where, the owner of the vehicle, it may be co-owned, right, by the couple, maybe owned by the spouse, but used very regularly by the survivor. And because in those instances, there's some kind of co-ownership or other ownership, what the manufacturer is doing is essentially curbing ownership interest, because we would be shutting off your ability to remotely access your car, find out where it is, GPS, which is a feature. And so in order to do that, when you have a possessory interest, in order to curb your possessory interest, there would have to be some kind of request or indication that there is a need for that.
Yes.
I get that, but it seems like it seems like that's a determination that this statute is still asking be made of the car manufacturer. And so they have this quandary in the status quo of determining ownership.
Right.
Or determining whether or not in a co-ownership situation it's appropriate to do it. Why do they need, or what do they get from the statute that they couldn't just have by making that determination now? Because it still requires them to make that determination. And they could still get it wrong.
Right. I will propose an answer that might not be correct. This is just me, right? So I would have to collect. I believe it's probably a litigation shield. Because the risk of shutting, they don't want to bear the risk, right, of accidentally shutting off someone's services and then they come sue you because it's possessory interest and da 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 da. So in order to make it streamline the whole thing and make it easier, the litigation shield is in there. And certainly hear the concerns of the advocates with respect to the scope of that, which is another issue. But I think that the general matter is just some kind of litigative protection against the curbing of the possessory interest by the owner.
You can ask your follow-up.
My instinct was that, but I still don't feel like it's probably a very adequate one, because if they get it wrong, they're still going to get sued.
That is a question I would have to go back to the client with. That's very valid.
Other questions? Yes, Representative Crusoe.
Are you aware of any issues with insurance companies not being willing to insure cars where they can't, for theft or anything like that, if they can't, the location services are developed?
So I think Janet may have touched on this in her
I missed it.
overview.
Sorry.
Oh, no, that's okay. And no was sort of the answer to your question.
Yes, so the Bureau of Insurance's letter in response to that question is the last attachment. Well, it's not a letter, it's emailed to me. But they basically said there may be some insurance companies where you get a premium discount by using telematics. But there are other ways to do telematics other than just these connected vehicle services, so you wouldn't be shutting out that possibility of a premium
Missed
discount.
it. Sorry, thank you.
And if I could just, I think this is being informative to your question,
Go,
Representative Caruso.
yeah, go ahead.
Thank you. Because I heard you talk about this in the overview, and I thought it was a really good point. Right now, you may all recall the recent, kerfuffle around automotive right to repair. There is a connection here, and the connection is telematics. So, and this is just to give you a sense of how these cars are working right now. Right now, most vehicles are not what we call connected vehicles in the United States. In fact, there are very little, and those that are rolled out, the services are pretty minor, like a GPS connection or emergency services, Starlink, or you may have heard of that kind of thing. In Europe, the cars are fully connected, meaning there's a constant back and forth pinging of the cloud to the manufacturer, and information is coming and going, and the consumer can choose to share that with, say, an insurance company or other entity. Right now in the United States, because the law is, very much up in the air and there are different laws on the books, manufacturers are not actually rolling out connected vehicles in the United States. So to your question, the way they're getting that information right now is often through like a physical plugin, or maybe you can download it and share it later with the insurance company. But because manufacturers aren't really using connected vehicles and aren't rolling them out, I'd be surprised if insurers start requiring that unless and until connected vehicles really hit the market, if that helps answer your question.
Thank you for that additional information.
Thank you very much.
Yeah, other questions, committee members for Elizabeth Frazier?
Great,
Seeing
thank you.
none, thank you. Is there any other information committee members wish to seek or discussion, or would anybody like to make a motion in order to frame our discussion? Representative Poirier, would you like to introduce yourself?
Sure.
And then I'll recognize you, Representative
Thank
Lee.
you, Madam Chair. I'm Jennifer Poirier. I represent House District 70, which is Skowhegan.
Representative Lee?
I'm still stuck at why this is needed. And I think I'm gonna remain stuck there, so I'll move on not to pass.
So there's an ought not to pass motion. Is there a second on that motion? Seconded by Representative Poirier. Any discussion of the motion? Representative Pugh?
Thank you, Madam Chair. I think I'll support the motion. I think this is an important policy area, but I think that the concerns that were raised and the idea of strengthening it feels very important. I don't feel qualified to do that right now, but I do think I'd like to see a stronger version of this pass. So I'll support the motion.
I would just add a reflection that we've just heard that there's not a lot of these connected vehicles, so it doesn't seem like it's as pressing as it will become, and there's time to continue to work on the issue. Any other discussion, committee members? Seeing none, is the committee ready for a vote? It appears that we are. Clerk Panett, thank you.
Senator Carney.
Yes.
Senator Carney votes yes. Representative Kuhn.
Yes.
Representative Kuhn votes yes. Senator Hagan. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Sinclair.
Yes.
Representative Sinclair votes yes. Representative Pugh.
Yes.
Representative Pugh votes yes. Representative Henderson.
Yes.
Representative Henderson votes yes. Representative O'Halloran.
Yes.
Representative O'Halloran votes yes. Senator Talbot Ross. Representative Lee.
Yes.
Representative Lee votes yes. Representative Sato. Representative Babin.
Yes.
Representative Babin votes yes. Representative Caruso.
Yes.
Representative Caruso votes yes. Representative Dana. I'll recall the absentees. Senator Hagan. Senator Hagan is absent. Senator Talbot Ross. Senator Talbot Ross is absent. Representative Sato. Representative Sato is absent. Representative Dana. Representative Dana is absent. Madam Chair, I have 10 members voting in the affirmative, 0 in the negative, 4 members are absent, and that is the vote of the committee.
Thank you very much. And so the ought not to pass is unanimous among those present, and the remaining committee members will have a chance to register their votes. And so we will close the work session on 2120 and take a pause. Committee members, contrary to my previous statement, I wanted to let everybody know that we're actually going to move on to the last listed bill at this time, and that's LD 2059. And this is an act to provide required funding for the reimbursement of assigned counsel and to develop the Public Defender Office for Cumberland County. So we'll open the work session on that legislation.
So we've already had a work session on this bill, and you asked for more information about the caseload standards of the Maine Commission on Public Defense Services. So that is the white handout that you have. It's the actual rule for the caseload standards for assigned counsel and contract counsel. So these are the folks who are in the private bar assigned to individual cases and how many total indigent legal services cases they may have at any one time. And then there is an explanation email from Director Tarpinian about how those caseload standards work. And then also Representative Henderson has a proposed amendment for you to consider that was handed out on the yellow paper. And I'm happy to talk about whatever you direct me to.
Thank you. Representative Henderson, would you like to describe your proposed amendment?
Yes, thank you, Madam Chair. So I know last year at this time, we had a similar conversation around funding for PDS. There was, we were also discussing a few different things, but the governor's office had brought forward a few concerns at that time that might have been a little bit more relevant to the subject at hand. But one of those concerns was that currently PDS counsel is classified in state law as a classified position. And those classified positions give them the authority to enter into collective bargaining agreements. We had kind of somewhat flushed out a little bit why that was, or could not just potentially be concerning, but why it really was concerning. And what this amendment does is it attempts to address that, to shift them from classified positions to unclassified position under the definition of state employee, which can be found on the, my reference to that can be found on the second page of this amendment.
Thank you.
You're welcome.
Are there questions for Representative Henderson? I have a question for you. We all know that we have public hearings on issues that are presented to the legislature, and it's a very important part of our committee process. I don't recall us ever having a publicly noticed hearing on this issue of the status of PDS employees under the State Labor Relations Act. And I think I would have noticed that if had we had a publicly noticed hearing, because I think some of those employees probably would have come to this committee and shared with us how they felt about that. And so I'm just, because my question in a long-winded way to you is, has this issue ever been publicly noticed?
So to answer your question directly and not like a politician, the answer is no, it hasn't been publicly noticed. But in the 132nd, so last year when we had this discussion, many from PDS came forward after reading the governor's testimony or seeing the governor's testimony submitted. Many came forward and shared not only their concerns for, but also in their concerns for or reclassifying, as well as their support of. So it hasn't been at an official public hearing, but there has been dialogue within the 132nd on a public forum on this matter.
Not in connection with LD 2059.
In connection with the PDS funding bill.
Gonna re-ask the question. Sorry to be a stickler, but in connection with this bill to which you're proposing this amendment, has that issue been publicly noticed?
You're the one that's in charge of public notifications, so I think that would be a good question for you.
And I will just say that I don't feel it has, and I appreciate that you wish to make this policy change, and the point that I'm would like to make, and I'm not trying to the point I would like to make is that if we're going to make such a significant change in the employment positions of many employees of the state of Maine, that it should be publicly noticed and they should have an opportunity to look at the proposed changes in the law and then speak to this committee so that we understand the consequences of it. And I don't feel that that's happened in conjunction with this bill. But thank you for bringing the amendment forward. Other discussion committee members? Yes, Representative Lee.
I'm looking at the amendment and I'm trying to understand the part. So there's two parts here, right? There's one that deals with employed counsel, and then there's one that deals with the unpaid amounts for appointed counsel for folks who are not unionized, who are not part of the public defender offices. Is that part still in here? The emergency funding for those folks?
Yes, yeah, if you look on the second page, that hasn't been removed. Just Senator Carney's proposed removal of the 11 positions for Cumberland County PDS. But the funding, the $13 million funding absolutely is still part of that. Or 13 million for this year and then 9 million for the next.
Go ahead, Representative Lee.
And as to that part, it looks from this amendment that you've removed the emergency provisions for that.
If you look at the top of page 1, like the underneath, so like the technically the 5th line, it says retain the emergency preamble and
okay,
emergency
gotcha,
clause.
Gotcha. I just didn't see the emergency preamble.
Yes.
Okay.
Other questions? Oh, actually, before we do that, Representative Sato, would you like to introduce yourself?
Thank you, Madam Chair. Good morning, everyone. My name is Ellie Sato. I represent House District 109 in the beautiful town of Gorham.
Representative Poirier.
Thank you, Madam Chair. It's not a question or anything but a comment for Rep. Henderson's proposed amendment. I do support this, and the reason why is every year we're continually asked for funding for PDS, and we know it's important, but also I see her amendment as being significantly important to the whole PDS structure, because having attorneys unionized in this manner is significantly affecting how many cases they can take, the hours they can put in. And that is part of the cause of why we need assigned counsel. I think it all jives together here, and it is something that needs to be addressed before I'm comfortable continuously adding more and more money. So thank you, Representative Henderson.
Thank you, Representative Poirier. Other discussion or questions, committee members? Representative Caruso?
Thank you. I'm just looking through my file. I understand that you amended your bill to remove Cumberland County. Is that right? So I just don't have that.
That-
version.
So that was never prepared as an amendment. It was just noted in, in the bill analysis that Senator Carney has suggested either removing Cumberland County provisions or maybe using those positions for a different thing,
I
but
see.
that hadn't been drafted yet because it hadn't been decided yet.
Okay,
I believe.
sorry. I found it.
Oh, thank you. And can I just take your comment as a question and clarify for everyone? I did suggest that we amend the bill to remove the provisions related to Cumberland County office because what we heard at the public hearing was that the needs have shifted a little bit. And rather than using this emergency bill to kind of sort out where those other positions are needed, I think that it's really more important to focus on what we know is the urgent need, which is the money that is needed as of April 1 to pay assigned counsel for work that they have already provided to the state of Maine prior to April 1 and have will be billing the state of Maine for between April 1 and the end of the fiscal year. And so when I first prepared this legislation, there was an urgent need in Cumberland County. That urgent need has been addressed by the commission, which I think is great news that we see how nimble and able the commission is to respond. And so I just want to reduce it to the thing that's urgently needed. I mean, imagine submitting an invoice to PDS for a year or two worth of legal work defending someone in a very complex criminal case and being told that there's just not the money available to pay you right now. And that's my rationale. Other discussion, committee members? Representative Henderson?
Thank you, Madam Chair. I'm also willing to provide a little bit of context as well. I know in the discussions last year, it was uncovered that it was, so three parts. It was never the intent of the legislature to have these positions be quote unquote classified. There's no legislative intent to support that. And it was never the intent of the governor's office to have them be classified. Where it gets a little bit more into the gray area without having somebody actually from DAFS who was in part of, the conversation between the commission and them on how to create or where to create this position. In conversations I've had with a couple different people from both sides of the aisle has been that it seemed to be that DAFS did the best that they could to find the right place for them within the billing and the financial side, but that the outcome of that was that now we have public defender's office who can enter into collective bargaining agreements. And while we have an avenue right now to study that, which I've supported, that doesn't actually address the real issue here in that there is a lack of parity and that we as a legislature have effectively handed over our legislative authority to a union to negotiate things that we should be establishing in law. And where this is a constitutionally required thing for the state to do to provide defense, I think it should be viewed differently than other state employees. I know we have some state employees that are allowed to enter into collective bargaining agreements, but I think that this needs to be handled differently. And if we really are looking for parity between the DA's office, the AG's office, PDS, I think that starts with making sure that everybody starts off with the same thing and doesn't have the benefits of someone bargaining for you on your behalf that others don't.
Representative Kuhn?
Thank you. I wanted to clarify a couple of things. First, the bill as it's proposed to be amended removes any payment for employed council. So we're talking about money for services already performed by contract counsel. So it makes me feel even more strongly that that amendment isn't relevant to the actual bill that I think we're proposing advancing. So that's one thing. The second thing is that just yesterday, we did language review on a parity study to look at how similar or different these jobs are and to ensure that compensation is fair and appropriate. So if there's a question about their union status, it seems to me it was relevant to that study yesterday and where it can be thoroughly looked at instead of brought in at this time. So I would just offer those reflections.
Yes.
Thank you, Madam Chair. When I originally had begun the discussion here about this amendment, I actually alluded to the fact that having this discussion last year on 1101 felt a little bit more relevant than it is here today. So I do appreciate you bringing that up, and I tend to agree. But we are talking about a relatively large piece of funding for PDS, and a entity that I have historically supported in my legislative career, but also have supported real checks and balances. And although the checks and balances I'm asking to be put in here today aren't reflective of what the money ask is for, because the money ask is for assigned counsel, it is reflective overall of PDS. And it's my understanding that when we did have the discussion earlier about the study bill, that we had talked about that one of the factors we wanted them to consider, the study to consider, was the fact that they have collective bargaining agreements. So I still think it's an important discussion, and I'm not looking at this through rose-colored glasses here. I understand the logistics of what happens and how many of us are sitting around the horseshoe that are going to support this. So I think that still needs to be discussed in that study group. But I do think that we also need to continue to talk about the fact that they should not be classified.
Representative Lee?
It's a 100% to me a legitimate discussion, and one where we're going to differ on the importance of collective bargaining for public employees. But I really have difficulty, given just how fragile the public defense system is right now and its dependence on assigned counsel in its current state, that we're going to have as collateral damage to that important policy discussion a number of people who have done work, have not been compensated for that work, and will simply stop doing that work. And then we're in another Sixth Amendment crisis in the state of Maine. And so I agree that it's a conversation we should have going into the future. I'm struggling to do it on this bill where we have emergency funding that needs to happen for assigned counsel.
Other discussion? Go ahead, Representative.
Thank you, Madam Chair. And I agree representatively on some of your points there. And I think you might be surprised that we might be closer on the collective bargaining agreement piece when it comes to public employees. But I would say that this doesn't have to not pass as an emergency, right? Like, we could move forward with reclassifying these positions as a committee, and we could unanimously vote that this is something that we want to do. This isn't a one or the other. My amendment has that emergency preamble. It has the funding on it. So it's not as if we have to vote one or, either they're going to get paid or they're not. There is a path forward here where they're reclassified and paid. And it's a very clear and present path forward.
Any other comments, discussion? Yes, Representative O'Halloran?
Thinking about what Representative Lee said, what really stands out to me, certainly, it was referenced, they come to us every year for money. Well, sitting here, my first term, they certainly are not the only people that come to us every year for money. They're just one of many. So I don't see how we can single them out for that. And that's a little disingenuous to me. But the important thing, and I think our study is going to get to parity as it should. But one of the biggest reasons for me, that I firmly believe that they need to be part of a union membership, especially in the beginning stages, as Representative Lee mentioned, is that they have to take the worst of the worst criminals. And they can receive major public backlash for representing these people and their, constitutional obligation to represent these people, which could, in some sense, destroy this department, especially where it's in the beginning stages. Other attorneys have the right to refuse to take on these types of clients. And that's one of the biggest reasons that, from my understanding, being here new, that PDS was formed. And I really think that we have an obligation to stand firmly behind them. I think we have an obligation to defend them in these positions and then see where it goes. And I feel very strongly about that. I think everybody should have their due process.
Thank you. And I just also wanted to highlight, I think I said this at the public hearing, perhaps, but that in the 6 years that I've been working on this issue, we have, the state has taken back $10 million worth of funding from PDS. And also that when the state acted to increase the compensation rate for assigned counsel from $80 an hour to $150 an hour, we did not increase the baseline. And so this emergency funding would simply fill in the gaps that we created in prior decisions of this legislature that have led to an inability to pay the assigned counsel at this time. Everybody is very quiet. So it seems like perhaps we want to have a brief corner caucus and come back in about 5 or so minutes. Does that seem reasonable? Okay, let's do that. We are at ease for about 5 minutes. Thank you, everyone, for returning from corner caucuses. We're back for the conclusion of our work session on LD 2059. I'd like to recognize Representative Kuhn.
Thank you. I'd like to make a motion ought to pass as amended. The bill as printed with the removal of lines 34 to 41 on page 1 and lines 1 through 4 on page 2. So in other words, removing the physicians for the Cumberland County office and retaining the one-time emergency funding to address the shortfall.
Thank you. Seconded by Representative Sato. Yes, Representative Sinclair, did you wish to be recognized?
Thank you, Madam Chair. I just wanted to check in with Representative Kuhn and see if she intended her amendment also to strike lines 20 through 25 on page 1.
Thank you for finding that. Yes, I did intend that.
And so just, can you clarify what those lines are, Representative Sinclair, just so that people aren't guessing?
You want the
Mem-
whole set, Madam Chair, or just the ones I just added?
Just the suggestion you just made. Members of the public may not have the bill text in front of them.
Lines 20 through 25 on page 1 are just two whereas clauses that no longer apply after the amendment suggested earlier by Representative Kuhn.
Thank you. Is there any discussion, committee members? Representative Henderson?
Thank you, Madam Chair. I will not be supporting the motion that Representative Kuhn put forward, but instead will be still fully supporting the funding, but as well as the classifications. And then for those who may wish to join me in my vote, would not, my report won't be the full yellow paper in front of you. It will be crossing out the first section 1 MRSA 959 so that we're not making PDS employees major policy influencing positions, but it would just be to classify them or to declassify them and put them under the state employee provisions of law.
Thank you for that clarification. Any additional discussion, committee members? Not seeing any. Is the committee ready for a vote? So this is a vote on the ought to pass as amended motion by Representative Kuhn, seconded by Representative Sato. And that motion includes a slightly adjusted emergency preamble and then the funding of the money to compensate constitutionally and statutorily required assigned counsel in this fiscal year. And with that, is the committee ready for a vote? Appears that we are. Thank you, Clerk Panett.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Representative Kuhn.
Yes.
Representative Kuhn votes yes. Senator Hagan. Representative Poirier.
No.
Representative Poirier votes no. Representative Sinclair.
Yes.
Representative Sinclair votes yes. Representative Pugh.
Yes.
Representative Pugh votes yes. Representative Henderson.
No.
Representative Henderson votes no. Representative O'Halloran.
Yes.
Representative O'Halloran votes yes. Senator Talbot Ross. Representative Lee.
Yes.
Representative Lee votes yes. Representative Sato.
Yes.
Representative Sato votes yes. Representative Babin.
No.
Representative Babin votes no. Representative Caruso.
No.
Representative Caruso votes no. Representative Dana. I'll recall the absentees. Senator Hagan. Senator Hagan is absent. Senator Talbot Ross. Senator Talbot Ross is absent. Representative Dana. Representative Dana is absent. Madam Chair, I have 7 members voting in the affirmative, 4 members voting in the negative, 3 members are absent, and that is the vote of the committee.
Thank you very much. And so, Representative Henderson, I'll turn to you first. Is your report the yellow sheet minus section 1?
It is, but also including not only the emergency preamble, but all of the whereases, if those are that's a word, minus lines 20 through 23. 25 rather.
Great, thank you.
Thank you.
And then for those who voted no on the motion, is that your report as well?
Yes.
Seeing lots of nodding heads. Thank you, everyone. Janet, do you need anything else from the committee at this time? Okay. And so the ought to pass as amended, received 7 votes. The 4 members voted on an alternative report, and then there are 3 members who are absent who have until noon Friday to register their votes. And with that, we will close the work session on LD 2059. And committee members, we're going to wait. I was going to say we're going to wait a moment until the bill sponsor for LD 2163 arrives, but she has just arrived. Yeah.
All right, Janet, I think we all have the materials whenever you're ready.
Certainly. So LD 2163, as Chair Carney said, is an act to improve the response to complaints by victims of crime and enhance victims' rights. So under current law, just so you understand what rights we're talking about, this was distributed at the public hearing. A victim of a crime or immediate family member of the victim in certain circumstances has the following rights. So the prosecution must make a good faith effort to notify the victim of the details of a plea agreement before it's submitted to the court and the victim's right to comment on the plea agreement. The prosecution must also notify the victim of a make a good faith effort to notify the victim of a proposed dismissal or filing of the charges against the defendant before court action is taken on that proposal. Also, good faith effort to notify the victim of the time and place of the trial, the time and place of the sentencing, and the victim's right to participate in the sentencing hearing. Good faith effort to notify the victim of the termination of the defendant's probation, including the right to comment on a proposed early termination of probation or administrative reliefs. Also, notification of the final disposition of the charges against the defendant and of the victim's rights as outlined here. So there's a pamphlet that also includes information on the victim's compensation fund that has to be made available. Other victims' rights include a right to notice of release or escape. So if a defendant is convicted of a crime or found not criminally responsible by reason of insanity or found incompetent to stand trial, and so they're in the custody of the Department of Corrections, a jail, or the Department of Health and Human Services, and if the crime is a Class A, B, or C crime, or a Class D crime under the offenses against the person provisions of the main criminal code, sexual assaults, or sexual exploitation of minors provisions of the criminal code, then the victim can file a request for notification of the defendant's release or escape with the prosecution, and the prosecution is directed to forward that to the entity with custody of the defendant, and those entities have to notify the victim of the release or escape as outlined, including like releases for work, furlough, things like that. The victim also has a right to notice of release on pre-conviction bail. So if the defendant is charged with domestic violence, sexual assault, or stalking, the arresting officers required to obtain the victim's contact information. And if they're released on pre-conviction bail, the arresting officer or the jail, depending on where the defendant is, has to notify the victim as soon as possible, but not later than 1 hour after the release, although the victim can request not to be notified. And then there's a separate victim's right provision in Title 34A of the Maine Revised Statutes, which governs in part the Department of Corrections. And so they have an Office of Victim Services and have different rights that victims have through that office. And those, through the sponsor's proposed amendment to this bill, wouldn't be part of this process, but I wanted you to know that they exist. So a summary of the bill as the sponsor proposed amending it at the hearing is that it would create the following new victims' rights in addition to the ones mentioned before. So a victim would have the right to timely notice of and an opportunity to be heard at any court hearing or proceeding in a criminal case involving a subpoena for the victim's medical or mental health records, education records, or cell phone records. The victim would also have the right to timely notice of the filing, scheduling, and outcome of an appeal in that criminal proceeding. And the victim would have the right to retain an attorney, but not at public expense, and to either have the attorney speak on the victim's behalf during any interaction with the criminal justice system, or to have a victim witness advocate or coordinator speak on the victim's behalf at any court proceeding. So that's one section, is those new victims' rights. The other major part of the bill is that it would direct the Attorney General to create a centralized complaint process through which a victim can allege a violation of their rights, except those rights involving that Department of Corrections Office of Victim Services. Those are treated separately and not part of this process. So victims must be notified of this potential complaint process in the pamphlet of victim rights that I mentioned has to be provided by prosecutors. The process must, quote, further uniformity, efficiency, and compliance, end quote, with victims' rights. The office must establish procedures through routine technical rules governing these investigations, and it has discretion to determine which complaints to investigate and may request and must be given access to information it considers necessary for the investigation. And the office, sort of as the outcome, may recommend that the entity complained of modify or establish policies and procedures, and then the entity would have to notify the office within 30 days of any changes it has made or hasn't made to the policies and procedures. The bill also provides that complaints made through this process are confidential and may be disclosed only to a person if necessary for the investigation, a state agency or criminal justice agency to carry out its statutory functions, or a community-based victim service provider. And then finally, the bill would direct this office for the victims' complaints to submit a report every January of odd number years to the governor, presiding officers, and chief justice with data on the nature of the complaints and against whom they were made, as well as any recommendations for improving the process. So as far as issues for consideration, unless you want me to stop,
We can just pause for a moment. Are there any questions on the first part of the bill analysis? Do you have a question? Can you put your mic on, please? Okay, yeah, no problem. Why don't you go ahead, Janet, and then we'll see.
Certainly. So one of the the first section which creates new victims' rights is this victim's right to challenge a subpoena for their records that's issued as part of the criminal proceeding. So there is a rule of court procedure. So it's Rule 17A of the Maine Rules of Unified Criminal Procedure that's attached. It's, I think, in white paper. And it establishes the process by which a party to a criminal proceeding can issue a subpoena on a non-party that commands that person to produce documentary evidence or tangible objects at the time and place specified in the subpoena. The rule contemplates that notice of that subpoena must be provided to the opposing party, but it doesn't have any provision about providing notice to the subject of the records. So in this case, if it's the victim's mental health records that are being subpoenaed, and they're being subpoenaed by the prosecution, the defense would get notice. And obviously, the entity from which the records are subpoenaed would get notice, but not the victim themselves. The subpoena non-party or a party, or even the person whose rights are potentially affected, may file a motion to quash the subpoena. So they're not directed to give them notice, but if they find out, they can file the motion to quash the subpoena. And the court may quash or modify the subpoena if compliance would be unreasonable, oppressive, or in violation of constitutional rights as the original subpoena request was written. If the subpoena seeks information specifically that's subject to a privilege under federal or state law or the main rules of evidence, for example, confidential medical records, then Rule 17A has a provision that requires the party seeking those records to file a motion with the court before issuing the subpoena, explaining that the moving party cannot properly prepare for trial without such production of the documents, and that the requested information is likely to be admissible at trial. After that motion is filed, the court has to set it for a hearing and direct the non-party to provide the documents that are at issue for in camera, which means without making it public, review by just the court. And then notice of the hearing must be provided to the opposing party and the non-party to be subpoenaed. But again, there's no provision in the rule to require the person who's the subject of the records, in this case, the victim, to be notified. After the hearing, the court may issue any order necessary to protect any parties or non-parties' privileges, confidentiality protections, or privacy protections under laws and rules, federal and state. So that could be, just as an example, this is very hypothetical because I don't practice in this area, but let's say I was the victim of a crime and someone subpoenaed all my medical records, maybe claiming, for example, that broken arm I had was actually 3 weeks old and really caused earlier. And if you look at the medical records, you could find it. Or maybe they're just fishing. I don't know what the reason is that they're issuing this subpoena, but they know that medical records are usually protected by statute. So they have to file a motion with the court saying, we need you to look at these records. So the doctor's office or the hospital would send all the records for the judge to review in private. And then there'd be an argument about how to limit or whether even to limit the request for records, or to maybe the judge might say, well, you haven't shown sufficient reason that you need these records, so we're just not going to let it at all. So all that would be sorted out at that hearing. And if that's a terrible example, please provide a better one. So as far as a proposed amendment in its testimony, the main judicial branch requested that the bill specify that it's the prosecutor's office, not the court, who's required to notify the victim when the victim's records are the subject of a subpoena in a criminal proceeding. And they noted that they don't have victim contact information, so they wouldn't be able to make that notice effective. I did want to note that the way the bill is written, one of the sections is put directly in the provision which says the prosecutor has to make a good faith effort to notify the victim of certain things. So that section, it's very clear who provides the notice. There is another section of the bill, however, which might be benefit from clarity in that regard if you want to add that language. As far as access to confidential records, at the hearing, questions arose whether the proposed language in the bill, as proposed to be amended, authorizing the Office of the Attorney General to request and be given access to, quote, information the office considers necessary, end quote, to investigate a complaint by a victim, whether that includes the authority to obtain otherwise confidential information. So there's a whole bunch of potential information that might be sought, and I'm not pretending to know all of the types of information that might be sought, but I did want to remind you of a few things that under current law, which was handed out at the public hearing, records of a victim's current address or location, or that contain information from which their address or location could be determined are confidential and can only be disclosed in certain circumstances, including to a state agency if necessary to carry out the statutory duties of its agency. So it looks like this would already be allowed to be shared with the Office of the Attorney General, but you may want to consider clarifying that. In addition, communications by a victim to a sexual assault counselor, a domestic violence advocate, or a victim witness advocate or coordinator are confidential under current law, and those statutes are attached. Each of these statutes allow a victim to refuse to disclose and allow the victim to refuse to allow the advocate or counselor to disclose certain confidential written or oral communications between the victim and the advocate or the coordinator or the counselor, and as well as any written records, notes, or memoranda concerning the victim. The statute that governs the privileged communications to a victim's witness, advocate, or coordinator, that specific statute does allow those records to be shared with the Office of the Attorney General, but there isn't similar language in the sexual assault counselor or domestic violence advocate statutes, which nobody is necessarily proposing you amend those statutes, but if you want that type of information to be shareable, that might be something worth clarifying in the bill about the victim's office. And then also there is the law governing intelligence and investigative records information, which is defined to include information of record collected by or prepared by or at the direction of a criminal justice agency. That includes law enforcement, district attorneys, the AG's office, or kept in that agency's custody while performing the administration of criminal justice. That information may be considered confidential if certain circumstances exist, including if the disclosure would, quote, constitute an unwarranted invasion of personal privacy, end quote. That suggests to me that information that might put the victim at risk could be considered confidential in this investigatory part of the process. But that current law specifically authorizes dissemination of this information to a person or public or private entity as part of the criminal justice agency's administration of criminal justice. And based on the definition, that might include sharing it with the Office of the Attorney General, but that might be something you also want to clarify. It's really up to you. And then I did want to mention that this bill with the proposed amendment from the sponsor, which creates confidentiality over the complaint system records, that would require a review under the Freedom of Access Act. So that review rubric is attached as the purple attachment. Since I wrote this, we received the testimony from CLAC or a report from CLAC. And if you want me to walk through the bill and show you the areas where they suggested maybe some clarity, I'm happy to do that.
Would that be helpful, committee members? Yes, all right.
Okay, so I'm looking at the proposed amendment because that's the most recent language. So the first suggestion they have involves on the first page, the subsection of 3360-Y that's called crime victim complaints. So this is about creating the centralized process for these complaints. And they suggested that it might be helpful to add language clarifying that the victim can't complain about a charging decision or a sentencing decision or sort of the outcome of the case. It's about only the adherence to the victim's rights statutes. Let's see if we turn to the second page. That's the establishing of the office, which is crime victim complaints in 3360-Y subsection 2. So just kind of clarifying the limits of that process, that it's just about the victim's rights laws, not about what happened in the criminal case or the prosecutor's decisions that they have discretion to make under established law. On page 2, the sponsor had added this confidentiality provision, which is labeled subsection 6. And this makes all of the information in the complaints to the office and everything confidential with only certain limited exceptions. And CLAC suggested that it might make sense to reference in those provisions the definitions of administration of civil justice. So it already refers to duties necessary to carry out the administration of criminal justice. And they suggested adding in about necessary duties for the administration of civil justice and then adding the cross-reference to that definition. Because there are certain things like civil violations or things like that, which could be violated that aren't considered the administration of criminal justice. The next thing is in what's now labeled 6A, it was subsection 6 in the original bill, where it says that the office can't be compelled to testify or produce evidence. They suggested adding language there to exclude any kind of constitutional obligation to turn over exculpatory evidence or things like that, about Brady violations, etc. A question I had, since we're looking in order, In number 8, this report does not go to a specific committee. It goes to the presiding officers, and it doesn't include any authority to report out legislation, even though it requires the office to provide recommendations about improving the process. So that's absolutely fine to keep it that way, but just think about whether you want that adjusted. The next thing Clack pointed out was at the bottom of the page, section 5. This is the notice to a victim of their right to be heard at any hearing about a subpoena for the victim's records. And they noted that requiring prosecutors to give this notice might be a large burden. And they did note, like the main judicial branch noted, that it would not really be possible for the court to provide those notices, and probably not a good idea to have the defense provide that notice. So I think they were just pointing out the burden of it. I don't think they're saying change it, but you should read what they wrote to see if I mischaracterized it. And then on page 3, section 8, which is also about the subpoenas for victims' records, Clack did note that there is this process in Rule 17A, which I summarized for you earlier, and they said, and they queried whether you need to create this statute or whether training people and making sure they actually follow the process would be a better approach. And let's see. Also in section 9, they had a couple of questions about this section 9. So this is the section that says the victim can retain an attorney and who can speak on behalf of the victim or have the victim witness advocate speak on behalf of them or the coordinator. And Clack was wondering, is the point to allow at any time when the victim has a statutory right to speak to the court, at sentencing or a potential plea agreement, is the idea to allow them to speak through the attorney or the advocate there? Or is it also intended to allow them to speak through the attorney during any kind of criminal investigation interview? So maybe the victim wouldn't be there and only the attorney would be there. So they questioned whether that was really the intent. And then also there's language in here, it's the beginning of the second sentence that says treatment of the victim may not be affected or altered in any way because of the victim's decision to exercise this right. And they noted that if the victim is represented for purposes of this proceeding, there may be some obligations on the part of the attorneys for the defense and the prosecution not to communicate directly with the victim, because a representative party, you're supposed to communicate through the attorney, not through the client, if they know that there's an attorney involved. So those were the issues that they raised, and I hope I didn't mischaracterize them.
Thank you for walking us through that. Are there any questions for Janet on those amendments? Representative Henderson.
Thank you, Madam Chair. This question may be better suited for the advocates that know, but who is responsible for notifications, or does it change based on what the individual is being notified about?
So I can start to answer, but then people who really know can finish answering. On page 1 of the current law handout, in section 2102 of Title 17A, there's a lot of notice rights to victims.
Janet, can you just pause 1 second if people want to get that out?
Oh, sorry.
It's a separately stapled document, not the
It's
buff
from the
that's
hearing.
attached.
Right in the middle of the page, victim to be notified. And so under that, all of the rights to be notified in this list are that the attorney for the state, so the prosecutor, would make a good faith effort to notify you. There are some rights about notification for the defendant's release or escape from confinement, and those the victim communicates their desire to be told to the prosecutor, who then communicates that to the facility holding the person so that they eventually make the notice happen. They effectuate the notice. And then there may be 1 or 2 other ones, but most of them are in this list in 2102.
But they're all noticed by the prosecutor.
Under current law, yes.
Okay, thank you.
Oh, there's one specific to domestic violence charges where the defendant's going to be released on pre-conviction bail. And that notification is from the law enforcement officer or the jail. So that's a slightly different one.
Representative Crusoe?
Thank you, Janet. This is helpful. Is there an indication of what it would take to actually fulfill what's required? Are they indicating that there would have to be a new department made, or can they do what what this is asking them to do with the staff that they have and just like write code to send notices out or something?
So as far as the creation of, I know this is what you are asking, but the centralized complaint process in the Office of the Attorney General, I don't know what they would say. We do have representatives from that office here today, if you want to ask that question. As far as the notice, all I know is what the Criminal Law Advisory Commission said, which is where it says CLAC members noted the significant burden this could impose on the state as far as giving notice of the subpoena record, the records request. But they are required to do these other notifications already, so that's really a question maybe for the Prosecutors Association.
Would you like to ask anybody else that question?
I believe that MCEDB is willing to answer. Oh, sorry, the Office of the Attorney General.
Okay, thank you. If you could
I
come
saw
up
the
and
wrong pointing finger.
introduce yourself. Thank you.
Hi, my name is Kara Cookson. I'm the Director of Victim Services for the main Office of the Attorney General. The Victim Services Unit houses the Victims Compensation Program, and we also have a program called the Victim Witness Advocate Coordinator Program that provides training and technical assistance to victim witness advocates who carry out many of these victim rights for advocates statewide. With respect to the question about how the Attorney General's office would carry out the complaint procedures, we would need one additional staff member. That would be our analysis. We would need one additional staff member to carry out that function. Just given especially that we wouldn't want the training functions that we do to be tied in with that complaint process.
Thank you. Are there any other questions around implementation while we have Ms. Goodson? Yes, Representative Mahoney.
Implementation, but I had a question and looking this over about the perpetrators of violence against, let's just say, a woman, and then the ability for them to subpoena her like text messages and things like that. Is that regulated to just specific communications with certain people, or is it very broad when they're allowed to do that? I've never been involved in, so I'm curious.
I'm not a prosecutor, but I do work carefully when records are subpoenaed or when there's a motion to secure a subpoena. I'll speak very generally, and then if you had more specific questions, you could maybe ask Shira Burns and just say that the rule does require some narrow tailoring.
Okay.
It's not every case where text messages can be subpoenaed.
Thank you.
Representative Crusoe.
Thank you for being here, and this is helpful. Is there any way to know how often, like how common is this?
Are you referring to victim rights violations or?
Yes, and victims not getting notified when all these things that are listed.
Yeah, so I'll share from my experience because the Attorney General's office does receive calls and emails from crime victims when their rights aren't observed. Crime victims thinking like, oh, we should call the Attorney General's office. The Attorney General's office fixes things. And that's true. There's a lot of stuff that sometimes we can fix or at least provide information. Often those calls come into me. And I would say that I receive at least a couple calls a month that are specific to victim rights violations. Some of the common issues that come up are court dates changing 24 hours ahead of a hearing, let's say, or a matter being scheduled 24 hours ahead of time. And that information makes its way to the prosecutor's office that has to notify a victim, and there isn't enough time to make that happen.
So that's one example of the types of things that I see frequently. We do have a fair number of situations where victims they weren't notified of the plea agreement before the court entered the plea. And I think often in those situations, it's again, the pressure trying to clear the docket as quickly as possible. And so if on a given day, we've got the defendant here, we've got the prosecutor here, we've got a deal, but nobody's talked to the victim, I think sometimes those are situations where there's a lot of pressure on prosecutors to try to move cases quickly, and a lot of pressure on the courts. So those are the other ones that I tend to see. And I work with victim witness advocates who call all the time about situations that they're in where they're having to deliver bad news to victims after rights have been violated. They're trying to explain why they didn't have prior notice. So is it the most common thing I see? No, in my work, but it definitely comes up from time to time. And we also get calls from people who are really upset with how the criminal process played out. And one of the things that I think sometimes I'm able to do, and that I think this program could do that would be helpful, is to back up the process and say, I know this feels really unfair. I know this isn't the outcome you wanted, but this is the way that the process works here. And you're not being singled out. This isn't a case of your rights being violated. This is a case of prosecutor using their discretion or the court using their discretion. And sometimes we can direct them to services and help provide other forms of support, because the criminal justice system is not the only pathway to healing and recovery from victimization. And we try to help people find those other avenues.
Thank you.
Other questions? All right, thank you for joining us. Do committee members have questions for other folks who are here with us? We have Andrea for MCV. We've got the bill sponsor, others. Judicial branch. Representative Lee?
Actually, I have a question for Janet. I've reread the Section 8 concern from Clack several times, and I do not understand it. Can you maybe re-explain it to me from your understanding of it?
I think that they were making 2 points, and again, I can't speak for them, but how I interpret it is Section 8 of the bill, just to remind everyone, is the victim having a right to notice an opportunity to be heard when their own records have been subpoenaed as part of the criminal hearing. I think they were making potentially 2 points. First, it may be somebody else entirely whose records are being subpoenaed, who doesn't qualify as a victim, who isn't a party to the case, and they're also not getting notified under current law. So I think they pointed that out. And then also that there is that whole process in Rule 17A where the court and everyone involved is supposed to be narrowly tailoring any record request through a subpoena that would involve confidential information. And not only do you have to show the need for it, that it's potentially admissible at trial, but you're also supposed to not invade the rights of the person farther than need to be invaded. So I think they're saying that if people were trained and followed that diligently, maybe there wouldn't be a need for this, but that's really up to you to decide.
It's that last part that I wasn't quite understanding, but I appreciate you explaining that.
Senator Carney?
Yeah, I have a question for the bill sponsor.
Great. Could you join us, please, Representative Gramlich?
Hi, Representative Lori Gramlich, House District 131. Thank you.
Thank you for joining us, and thank you for bringing this legislation forward. I was wondering, after hearing Kara Cookson from the Attorney General's office quantify the number of complaints that they receive about non-compliance with victim notification, it struck me that you might also have raw data about how frequently that happens, that either that notice isn't provided or that people complain about notice not being provided.
Yeah, thank you for the question, Madam Chair. This particular policy initiative was brought to my attention from advocates who may be able to answer that with a little bit more specificity. But it's my understanding that it happens with enough regularity that we wanted to bring this to a policy initiative to be remediated and addressed.
And then could I follow
Yes,
up?
please. Go ahead.
And then in the situation that Kara Cookson described of, the prosecutor and the defendant's attorney are all there in the court, ready to reach an agreement on a plea deal, and there's not time, that maybe that wasn't anticipated that it would happen that quickly. There's not time to notify the victim. What would the victim's remedy be under the process that you've outlined in this legislation?
I'm going to punt that to the people sitting to the right of me, if you don't mind, Madam Chair.
No, that's fine. I'm just trying to envision how this will all work. So, thank you very much.
Thank you.
Would you like to hear from someone on that question?
Yeah, I was just pausing to see if anybody had other questions for the sponsor.
Any other questions? Thank you for joining us.
Thank you.
Andrea Mancuso or? Sure, Ms. Cookson, whoever is the right person to answer that question.
So to the question of if there was a victim rights violation in terms of prior notice of a plea deal, for example, how we might envision carrying that out at the Attorney General's office, how this process would come into play. I think there would be information available at district attorneys' offices about the complaint process and that it's available. And a victim witness advocate or a community-based advocate would be able to offer that information, that you can make a complaint at the Attorney General's office. We probably create a phone number, maybe a online form or something, come up with a way to make it easy for people to make those complaints. The Attorney General's office has several different types of complaint processes already. So we'd build out something like that. And then from there, I think procedurally, it just looks like gathering that information and gathering the information from, in this particular situation, because the responsibility lies with the prosecutor's office, we engage communication with the prosecutor's office. And I'll say that's sort of what I end up doing now. Talking to victims, giving them a chance to be heard, really hearing them out, validating their experience, whatever it might have been. And then I often reach out to the victim witness advocate and say, hey, I heard from so-and-so, what's going on? Right now, how can we help? Is there, something that we can do to help with training or other forms of support? What kind of support do you need as an advocate? That's how it gets handled now. And I would imagine trying to build a system that's similarly like collaborative and really trying to support prosecutors, advocates, courts, whoever is involved in carrying out victim rights to do their best, because we know that everybody seeks to do right by victims. That's why people get involved in these jobs.
Thank you. Thank you.
Thank you. Representative Lee?
I don't know if you're the right person for this question, but if you think someone else is right for it, let me know. I'm trying to figure out on all this notice that's required to the victim,
Mhm.
who is supposed to be noticing it? What constitutes timely notice, and does it have to be written notice?
Sure. So the provisions that you're looking at, those notice provisions have been on the books, by the way, for probably 30 years. And there's a different provision, I think it's in Title V, that encourages every county to establish a victim assistance program. That's where we get victim witness advocates from. And so the statutory language says the prosecutor for the state shall make a good faith effort. And what has happened in Maine since the 80s is that victim witness advocates, and in some cases trial assistants, depending on the type of case in the county,
have primarily been the ones to carry out those notices. And it happens in different ways in different places. A lot of the notice happens by phone, so that there can be a conversation to assess needs and make referrals and answer questions about the process. There's nothing in the statute that says that it has to happen in writing. But there's certainly a practice that I encourage is when advocates do a notice over the phone is to document that in the file so that they can back up that it happened. And it's also helpful for the prosecutor to know whether the notice has happened for obvious reasons. So I don't know if that answers your question.
Do you have a follow-up?
I think it's as to the intent, whether by making this a right, there's an intent that those notice provisions become more concrete or, okay. I'm getting a head shake no from Andrea Mancuso.
Yeah. I mean, as I say, as I read the legislation, I don't think there's any intent to significantly change the provisions except where there's a couple new additions to the provisions. It's really just creating a mechanism to like allow victims to be heard where their system has re-traumatized them potentially, and create a mechanism to help improve the system so it doesn't happen again. And that's really all that this particular process can offer.
Any further questions? Senator Carney?
Trying to think of how to phrase this. I appreciate and understand the need for this legislation. I guess I have a concern that it sounds like for the most part, you're already doing this. And yet this process would put procedural burdens on survivors of crimes, victims of crimes. And I'm just trying to weigh in my mind whether having the more formal process in some ways, would it be a deterrent or would it help people bring complaints forward? What is your opinion?
I think it would help people to bring complaints forward. I think it would create a mechanism for there to be a more formalized conversation with the prosecutor. Right now, the conversations that I have are primarily with victim witness advocates. That's who I work with. That's who I have the closest relationships with. But and like I said, the piece that I do is very informal. It also creates a mechanism for there to be some transparency and oversight. There's been a question today about data, and there's a lot that we don't know. And there's a lot of gaps that we probably don't get to see. So it also like formalizes the idea that you can reach out to the Attorney General's office. So that would be my impression.
Thank you.
Representative O'Halloran?
Thank you. Listening to your response, I'm curious, so do you feel that this would be a good avenue and a way that victims themselves would actually feel empowered to maybe take a little more responsibility and like reach out to your office even on their own, not necessarily through their advocate?
Yeah, and some people do already, like I said, but I do think that it is creating some empowerment, giving people some avenue to feel like they can at least feel heard and listened to. And again, to be able, if they had a negative experience with the system, to feel like they're doing something to help make it better.
So you just want to
Follow up, go ahead.
So do you think this would be a good venue for your department and like even the prosecutor's office to actually learn more of what is going on the other side of this process and how it's impacting victims and where the shortfalls are?
Well, that's certainly, I mean, I certainly would expect that there'd be really close collaboration between sort of my role and whoever was in this other role. I think it would be important for there to be a wall on some things, but on the big picture issues, like, gosh, we're noticing a lot of X. We need to really train more on X. We could really work together and collaboratively to make that happen. And
I use the feedback that I get on the ground now to do that, but I think it would help us do that more and better.
Any other questions? Do committee members need to take a break? It seems like people are a little quiet. All right, why don't we take a break for just 5 or 10 minutes and we'll come back and proceed with the work session. All right, committee members, we're back in our work session. Representative Carney? Yes,
What? I haven't been a representative since.
I'm so
2020.
sorry. Good heavens. Senator Carney.
Thank you. I hold you in very high esteem, Representative Kuhn, and I was just teasing you because it's been a long day already and it's not even one. So, I've been thinking a lot about this legislation and we've heard some really important suggestions from CLAC. There are also some things that I personally am struggling with, worrying that this might end up on the appropriations table and wouldn't be funded. And so is there a way to accomplish the goals of this legislation without creating a new position? Probably not. But I think that there's more work to be done that we can't do today to find the right language and the right mechanism. And so I would hope that the bill sponsor and the Office of the Attorney General and Andrea Mancuso could all work together to come up with a draft that would incorporate the CLAC comments and would resolve the issues that Janet pointed out in the bill analysis before, and then we can look at it with fresh eyes and take it up at a future date. So that would be my suggestion of a path forward for this bill.
Representative Hugh.
Thank you, Madam Chair. I would move to table.
Okay. Is there a second? Representative O'Halloran? And tabling motions are not debatable, so we'll do a raising of hands. Who is in favor of the motion to table? All right, and that's unanimous of everyone present. Thank you. Janet, do you need anything from us on this matter?
No, just if I want to publicly say if they want me to help with the drafting of that, happy to help.
Thank you, appreciate that. All right, committee members, that concludes our work for the morning. Why don't we take a half an hour, so 1:25, and come back to the horseshoe.
Welcome back, everybody. We have two bills scheduled for this afternoon. For those who might be here for LD 1911, please note that we had to postpone that, and we will be taking it up at a later date to be announced shortly. And so we are going to take up LD 2150 first. That's an act to establish procedures for restricting access to state property, access to state services, and communication with or through state entities. And we are joined by legislative analyst Eli Murphy, as well as our committee clerk, Susan Panett.
Good afternoon. Eli Murphy, Office of Policy and Legal Analysis. SUPI should be passing out both my blue bill analysis packet, as well as you should be getting a white couple pager from the sponsor relating to her bill that I'm sure she can go over if you so choose. But turning to that blue packet, this is LD 2150, an act to establish procedures for restricting access to state property, access to state services, and communication with or through state entities. This bill prohibits an entity of the state from restricting a person's access to state property or services provided by the state, or restricting a person from communicating with or through the entity for a period of more than 90 days, unless certain conditions are met. It requires an entity of the state to include on a notice or communication restricting the person's access or communication the factual basis by which the entity's decision was made to restrict that person. The bill requires an entity of the state seeking to extend or renew a restriction issued by notice or communication for more than 90 days to file through the Department of Public Safety, Bureau of State Police, a complaint for a protection from harassment and provide evidence to the court of the original notice or communication restricting the person from accessing the property or services provided by the state, or restricting communication with or through that entity, along with the factual basis for the entity's original decision. The bill also requires the court to prioritize complaints filed for protection from harassment that are unrelated to the extension or renewal of a restriction for more than 90 days. At the public hearing, there was a question clarifying that point, and it was, I believe, indicated by the sponsor that it is effectively the intent is to deprioritize these protection from harassment complaints versus all other protection from harassment claims. So that was clarified. Finally, the bill clarifies that an action brought by an entity of the state and filed by the Department of Public Safety may be filed, heard, and determined in any division of the district court of the plaintiff's choice, and that the court may direct a defendant to refrain from being in the vicinity of state property. So turning to some current law that we've discussed, or that is discussed in this bill and was discussed a bit at the public hearing. Attached, you have the section, which is 17A, section 402, that is criminal trespass. Among the ways in which a person could be charged with criminal trespass are paragraphs D and E, which is a person remains in any place in defiance of a lawful order to leave that was personally communicated to that person by the owner or another authorized person. Violation of this paragraph is a Class E crime. Or by paragraph E, which is enters any place in defiance of a lawful order not to enter that was personally communicated to that person by the owner or other authorized person. Again, violation is a Class E crime. And so we've discussed at length the way that you reach crimes. And so there are a number of ways that you can reach criminal trespass. The ones that are contemplated by this bill or that are related to this bill would be those paragraphs D and E. Second is the harassment charge, which is 17A 506A. We will get to in your packet. There are some of the forms that the state police uses to issue these no trespass or cease harassment orders, one of which is the one that is contemplated in the harassment statute. And so that is 17A 506A. The relevant portion of that is subsection 1, which is the person engages in any course of conduct with the intent to harass, torment, or threaten another person, and then after having been notified in writing or otherwise not to engage in such conduct by any sheriff, deputy, constable, police officer, etc., the notification not to engage in such conduct expires 1 year from the date of issuance. or a court protection order issued under Title V, which is the protection from harassment orders, or Title 19A, which is the protection from abuse orders that this committee is very familiar with. And so the orders that we're discussing in terms of being issued either a notice of no trespass or a notice of cease harassment on state property by the state police, those are the ones that are contemplated in these two criminal statutes. Some issues for consideration. The first is venue. At the public hearing, Representative Sinclair did bring up a concern about venue that I mentioned in the end of my summary bit, which is that at the public hearing, with regards to the portion that allows for filing of a protection from harassment action, namely that the bill contemplates the plaintiff could file it in any district court they so choose. If the plaintiff is the state of Maine, that could be any district court. And so positing a situation where someone is, filed a cease from harassment order in York under this law, though I suspect that it wouldn't happen, a filing could be filed in a court in Aroostook County, something like that. And so if the court, or if the committee did want to make that change to limit that to just the venues that are applicable to the defendant, you could add language to the effect of proceedings under this chapter must be filed and heard and determined in the district court of the division in which either the plaintiff or the defendant resides, except that a proceeding filed pursuant to Section 60, subsection 3, must be filed in the district court of the division in which the defendant resides. And so that would be a change to the PFH statutes in Section 5 in a slightly different section than is in what is the bill text before you currently. In testimony from the judicial branch, they listed a number of concerns and issues for clarification. I know that a member of the branch is in the building. I've seen her. I don't know that she's in the room right now. But I do have that testimony attached to the packet as well, and we can go through those concerns. And then finally, copies of current trespass notices that were requested are attached in this packet as well. Those are from the state police, and you should have both. The first one is a no trespass notice, which would relate to the criminal trespass statute, the 402. And then second is the cease harassment notice, which is the one related to Section 506A. I've also included, or I guess I should say, no fiscal impact yet determined by our fiscal office. In your packet, I've also included the entirety of that PFH, the protection from harassment section. So you'll find that beginning on page, and I did number them this time. So in this packet, page 7 of the packet is that chapter 337A, which is the entirety of the protection from harassment. I know that there were some concerns about, does this type of action fit in with what is currently on the books for the protection from harassment statutes, namely the entity of the state of Maine or an agency of Maine being a plaintiff in a protection from harassment statute. So we have that full text there to discuss should the committee so choose.
Eli, thank you very much. Committee members, are there questions for Eli to start with? I am not seeing any. They may arise as we continue with the work session. So let's move on to hear from the bill sponsor, who I believe has prepared a memo for us. And Senator Grohowski, thank you so much for joining us again this afternoon. And I will turn over the floor to you.
Thank you very much, Senator Carney, Representative Kuhn, and members of the Judiciary Committee. My name is Nicole Grohowski. I represent Senate District 7, most of Hancock County. Thank you for having me back. I know that's the process, but I'm still appreciative. So I did send committee members and staff a memo this morning, so no worries if you haven't had time to look at it. But basically, I want to be as helpful and prepared for work sessions as possible. But as I dug into the bill and all of the great questions that you asked and that came up in the public hearing, it pointed out to me that there are some sort of major and minor decision points if there is committee interest in, I would say, sort of standardizing a process that exists but is not really well defined anywhere, and increasing due process for people who receive these sort of no trespass orders from state entities. So I didn't want to get working on an amendment and then find out that the committee said either we actually don't have an interest in doing anything with this legislation, or we really feel strongly about going a certain direction. And then I can get that guidance from you all, ideally today or at some point in the future, and then work on an amendment. So what I did with this memo was I tried to break down sort of the core questions that I was facing when working on the bill and that came up in the public hearing, and then identify what the decision points are in those. I don't know if there's like a way we want to go through that. I don't know if folks had any first reactions, if you had had a chance to look at it, but I basically split it up into the experience of issuing the no trespass order. How does that work? What information do people have? Do they know what their legal rights are to question it? That's sort of the first group of
Senator,
issues. Yeah,
if you
and
can
then
go through each group individually, but we'll pause after each one so the committee members can ask you questions.
I'd be so thrilled. Yeah, I'm serious. I'm really excited about this. I want to do something here and I want to do it right. But just so you know, here's the no trespass order issuance, and then the second section is really about how does somebody contest it? So that's the two sort of buckets these questions are in. So as we know, currently the no trespass orders are issued by the Capitol Police or local law enforcement on behalf of a state entity. That's the universe of notifications we're talking about. So we learned from the Capitol Police that before they issue their order, they have a process that is investigate the complaint, determine whether the individual had a right to be on the property to begin with, and if so, whether their conduct justifies a no trespass order. That raised a question for me about whether or not it was the case that other issuing agencies that are doing this on behalf of a state entity are following this same process. We heard some anecdotal evidence that made me think that maybe it's not consistent between the different types of agencies. So the question I had for you is, A, do we think the procedure is adequate? And B, should the procedure be required for all agencies issuing such an order?
If you could take us through the whole no trespass issuing
okay.
section, and then we'll break for questions.
Okay,
Thank you.
perfect. So then we learned at the public hearing that it is now the practice for Capitol Police, but not a requirement, that the factual basis for the restriction must be included in the order. This was my first opportunity in the packet from your analyst to see those orders. I didn't see a place on the orders that that's contained, so I'm kind of confused there. That aside, the question I had was, does the committee believe that it's appropriate to include the factual basis for the order on the order, regardless of what law enforcement entity issues the order? The next question is, there does not appear to be, from what we learned in the public hearing, any mechanism or requirement for different law enforcement agencies to notify other law enforcement agencies that a no trespass order has been delivered, even if the no trespass order would implicate a location in the jurisdiction of a non-issuing agency. So that question I had there was, should there be a requirement that the agencies communicate that they have put a no trespass order on a person? The example in my community was Ellsworth PD was aware that they had done it for DHHS at the Ellsworth location, but it was broadly applied to all DHHS buildings, and the Capitol Police, it sounded like we're not notified that that was something that they should enforce were there to be an issue here. And that seemed like a gap to me. Next thing we learned was that orders issued by the Capitol Police are in effect for 1 year. I was not able to find any information about if other agencies use that same duration. Is that a standard? I don't know where the 1 year comes from, so I identified more information needed. Is this coming from case law? Is it just, it's been a year and it's never been challenged, so we do a year? I don't know. Question for the committee was, should there be a default or a maximum duration for orders, and should that apply to all issuing agencies? And then the overarching decision that I have based on everything I've just said, related to sort of the potential different ways agencies are issuing these orders is, would it be more appropriate for the state police to be responsible for issuing a no trespass order on behalf of state entity regardless of where it is located? I think that's an overarching question. If so, if you think yes, then maybe the delivery to the person could be conducted by local law enforcement. So the state police are deciding it, but they could say to Ellsworth PD, hey, you live closer to this person. Can you deliver this for us? But it's coming from the state because it is a state request. So that was an overarching question. The sub question there, based on the testimony from the University of Maine system, was if we do that, would it make sense to exempt the higher education police departments because they do have other obligations under state and federal law that they're more attuned to than the state police might be? So that was my my bucket of questions related to the experience of a person receiving a no trespass order and how law enforcement engages with that.
Thank you. Committee members, are there questions for the bill sponsor or for anyone in the committee room at this time regarding that first chunk of issues, the issuing section? I do have a question. I'll pose it to the sponsor, but I suspect that the representative from the Maine State Police would be better equipped to answer it. And it's with regard to the first bullet point at the top of page 2. And so the question is, if conduct occurred, then let's say in Ellsworth, we'll just stick with that for simplicity. If conduct occurred in Ellsworth and was reported to the Ellsworth Police Department, would the Maine State Police be able to issue that no trespass or no harassment order, based on the investigation of the Ellsworth officer? Or how would that work, or would it just not work? Yes, please join us. Welcome.
Thank you. Chairs. Not conducive. My name's Tyler Stevenson. I'm a major with the Maine State Police.
Thank you. And I think you heard me. Do you need me to re-ask the question? Or are you able to answer it?
I got the gist of your question. Yes, we would have the authority. We have statewide authority. As long as, the facts and the evidence supported a no trespass warning. The struggle with that is, and as I said, my public hearing, a lot of these are ongoing events occurring right now. So this is all hypothetical, but there's an incident in Ellsworth occurring. Ellsworth PD is responding, maybe intervening in what is going on there. And it is much easier to issue that person a harassment, no trespass notice at that moment than to verbally warn them. And then the state police have to come track them down to issue that warning. That's a difficulty that I see. But if Ellsworth PD contacted us and gave us the information, we could issue a no trespass warning.
Is there another way that might be more efficient? For example, having Ellsworth issue the warrant and then having the Maine State Police follow up, or perhaps just having Ellsworth communicate with the Maine State Police? I'm trying to get you to brainstorm for us.
Ultimately, if the police department communicated to the Maine State Police, Capitol Police, and now we have a record of that, they could even send us a copy of their order so we're aware of it and the case report. That would be the quickest, cleanest way to do that. I will say that a police department in any town that has a state building would not have the authority to issue someone a statewide trespass notice to every state facility. I don't think that would be legal.
And so if you've received from the Ellsworth Police Department something that you thought exceeded the scope of what the Ellsworth Police Department could do, and a no trespass order, then would you be able to take some kind of remedial action to redefine the scope of the order?
I think we absolutely could. If through investigation, that person was deemed to be a threat to all state facilities, or what their action was so outrageous that, we weren't comfortable with them, setting foot in a state facility, then we could definitely amend it or issue our own at that point.
Thank you. Committee members, I know I've asked a number of questions. Yes, Representative O'Halloran.
How are you?
Good.
Good. I actually have a constituent that has reached out to me on this. One, well, they don't feel that this should change at all. But the question they have is, do you determine that, using the example that we heard in the first hearing, when you get those, do you determine whether or not the rights are being violated of that person? Like how do you just give somebody no trespassing order without knowing that they haven't even done anything yet?
We wouldn't, or I hope that we wouldn't issue a trespass order that wasn't justified in being issued. In this case, we didn't receive an order from the police department. We didn't even know it existed, which was a failure in communication between agencies. In that particular case, Ellsworth PD has jurisdiction of that building. It's in their town. It is a state facility, but they can enforce laws in that building. So they must have felt like they didn't need to share with Capitol Police or didn't have the education that they should.
Go ahead with your follow-up.
Do they also have the same responsibility of verifying that something is actually transpired before they can issue that? Not just that somebody was a roommate or associated with somebody who is under investigation. Shouldn't they have the burden of determining whether this other person legitimately should be trespassed?
Yes, and case law says that. In that case in 2002, you have to have a justification for the trespass. I can't just willy-nilly trespass people because, I don't like them. You have to have a reason. The issue with that, for that to come out, is it has to go through court.
May I ask just one more question?
You may.
Pretty please. So then instead of changing this law, then should we hold departments, whether it's state, county, or municipal, to that standard? Is there some sort of repercussion that can come against them for not doing their due diligence, for making sure that this is a necessary no trespassing?
First of all, I don't know what that entity would be. Typically, it's courts through hearings. Just if I violate your Fourth Amendment rights, I conduct an illegal search or don't issue Miranda, that is all gone through the courts and, through suppression hearings, and the evidence is tossed out and ultimately could become civilly liable for it. I think in this case, again, I know we're talking about an incident that occurred, and things will always occur because it's human nature and we're all humans. This process actually works. And it's worked so well that no one has really dove into it before. In the 124th legislative session in LD 777, they attempted to. They wanted to put a 2-year restriction on trespass notices and harassment notices. And that got boiled down to 1-year harassment and nothing about trespass, because if you're a small business owner or a private landowner and you don't want someone on your property forever, you have a right to do that. So you can't restrict the time limit on that. I know that we're talking about state facilities and maybe there's a carve out where we can specifically put a time limit on it. But I do need to say, and it's a tragedy what happened to this person, but there are people out there that need to be trespassed and are threatening and can be nasty. We have a receptionist that in the Department of Public Safety building that we've had to send home before because of harassment, and we had to stick a trooper there answering the phones and meeting the public, when things are happening out there.
Other questions, committee members, Representative Lee and then Representative Henderson?
Thank you. It seems fully consistent with the case law that you need a reason, and it has to be a legitimate governmental reason. And just sort of fundamental notions of due process say that you have to provide sufficient notice. So if we were to have a statute that required all of those things be in a trespass notice when it's a state building, would you have any opposition to that?
I wouldn't have opposition at all. We could just put a section on the form, we could handwrite it. They are all provided the case number, so they can obtain the incident report and read the whole thing themselves. But I personally, as a citizen of Maine, agree that people should have a right, unless their behaviors, prevents it, have a right to go to state facilities. So that doesn't seem unreasonable to me at all.
Thank you. Representative Henderson?
Thank you, Madam Chair, and good afternoon, Major.
Good afternoon.
I guess my question is really along the same lines as, like, when I'm viewing the fix for this, I'm viewing the necessity for state police to be able to have and be able to take immediate action to mitigate threat, but also ensure that the standard of that mitigation for threat is higher than what you would issue for a individual that owns private property, right? Because this is state entity, this is taxpayer funded property. My opinion, this is more policy piece, is that standard should be higher and the time frame should be shorter. It sounds like you are in somewhat agreement to maybe modifying that when it comes to public entities. Am I understanding that correctly? And if so, do you have off the cuff, or have you discussed it at all this weekend on what the higher standards for justification may be, as well as, I know you mentioned 180 days for a shorter timeline. I'm instinctively going much shorter than that, but maybe talk through what some of those parameters would be.
I think you have to weigh the security of the employees in this building. My building is easy because we have sworn law enforcement in it. So if there's a problem in the lobby, we just send a trooper down there, or, a fire marshal. There are obviously other buildings with state employees that don't have that luxury. Thinking it over, I do think that there needs to be a carve out for state facilities with a specific timeline. Again, I would highly recommend at least 180 days. A year seems to be working perfectly. We don't have to reissue. If we shrink that a little, hopefully that's enough for the person to reset or deal with the problems that they're having that triggered the no trespass. But as far as the standards, I'd be hesitant to be very particular on that, because the infinite reasons of why a person might warrant a trespass is hard to define. I can tell, it's not going to comfort you, but obviously, especially here, we're very careful that, just because someone is upset that day, that they're not getting trespassed. There has to be specific, actions that they're doing that causes concern that there's a reason why they shouldn't be here. But that's not law.
Right. Thank you.
Committee members, should we let this, thank you for answering our questions. Should we have the sponsor continue through her analysis of the issues?
Thank you very much. I think, and I do want to continue on, but I just want to say one thing, if I may, which is, I had an experience in 2024 reaching out to the Capitol Police on behalf of my constituent and asking, can you tell me the reason this person was no trespassed? And what the answer was that I received was, we do what the agency asks us to do. We don't look into whether or not we think that's valid or not. And that practice may have changed. We're in a situation where it was a different chief at that time, like a lot has changed since 2024. But I'm not fully satisfied that law enforcement is the one making the ultimate decision that a person should receive the no trespass order based on answers I got. You know, this is not third hand through the constituent that I got when I reached out to Capitol Police. And I just wanted to put that out there because I'm not sure it's as black and white as one might think.
I see lots of hands up, but I would really like to let Senator Grahowski take us through the contesting the no trespass order, because our objective today is to really determine what direction, if any, we want this legislation to take. And I feel like we could do a deep dive into a lot of these things, but right now we're trying to do a survey and then narrow. So if you could take us through the next section, please.
Excellent. Yes. So the next section was on the experience of contesting a no trespass order. So one thing that we learned in the public hearing was that these can be contested in court. We knew that. The DOC testimony had noted that one could use the main rules of civil procedure 80C as an option. I will admit this is not a language I'm fluent in, but I would just Google around.
Let me pause you for a
Yeah.
second. ADC would be challenging an administrative action.
Thank you.
Thank you. So, you know, let's say I was a person who received one of these orders. I'm Googling around, how do I contest this order? I did not find that there was any really obvious, readily available information about what somebody's rights were. And so, and I included in the email I sent you all this morning, the information from the Capitol Police, which says sort of what their process is, but not how do I react to it. And so I think one of the decision points was, should the order itself have information on it about how the restricted person could challenge the order in court. And where there's more information needed is that my understanding, and especially from Representative Lee's questions at the hearing, was in order to use the ADC process, there needs to be this final agency action. What would constitute such an action, and should the legislature compel an agency to get to that point so that a person then has the ability to go to court so things don't get kind of stalled because they didn't get the final action. So that was the first thing is, you know, for the rights that currently exist, do people even know it? How can they get that information? Then secondly, the MSP testimony had noted that a restricted person can file a complaint with the Capitol Police leadership. I don't know, does this denial, if they get a denial, does that constitute a final agency action that then allows them to get into the ADC process? And does the committee believe that that is adequate due process for a person, or should they be able to go just directly to the courts? Do they need to go through a lot of steps in a case like this where it's state property? So that's a question for the committee. And then the overarching decision that I think it's been on my mind for sure is, should a court decision be required for the state to restrict a person via a no trespass order? And that's really the crux of, there's all these other details, and I think there's a lot of room to improve what currently exists. This is the question about, should we change what currently exists fundamentally? And there was a lot of testimony opposed to the bill that was actually sort of for the bill in a weird way. Saying we don't think there should be anything like this without a court having a say, right? And so I think there's a lot of sub-decisions under that, which I don't know that we need to go through, but I sort of said, if the answer is yes, then there's all these other questions that need to be sorted out that have to do with, should it be 90 days or something else? Should the onus be on the state to start that process versus the restricted person? Is it okay to piggyback on the protection from harassment statute? Do we need to create a parallel statute that's cleaner and more dedicated to this exact purpose? Those are sort of sub questions to the big question, which is, should the courts be involved and in a way that they're not currently? And then finally,
Before you Lee, before you move on to something after the no trespass section, I know that Representative Lee has his hand up, and I don't know, Representative O'Halloran and Caruso, if your question was relevant to this section, but if so, please raise your hands. Go ahead, Representative Lee.
We're gonna get to some of the other discussions of alternative procedure, but I kind of wanted to put a pin in an idea that I just popped into my head is, I mean, we could establish that the issuance of the no trespass order is itself a final agency action via statute, and then they would have an immediate ADC petition for judicial review. The other thing that occurred to me is, what if we required in the notice an indication that the person has a right to petition for judicial review of that final agency action via the no trespass order? So that, I mean, you're one, establishing that they do have a petition right, which exists now, and you're informing them of that right upon the issuance of the order.
My comment to that would be, I firmly believe that when somebody receives the order, as much information as possible about what their rights are to respond to that order should be on the order. So I agree with, I think, what your latter question was, and the idea of sort of getting right to that final agency action, and not having a lot of steps in between resonates with me.
Other questions on this section? Yes, Representative O'Halloran.
I guess part of my question is, do you believe the focus should be, if your constituents' rights are violated, which it sounds like they possibly were, but do you think the focus should be on training the Ellsworth PD on the standards of meeting the standards for issuing the no trespassing, and maybe other municipalities, if they're not doing it very often, to know what the standards are that they should be looking for to meet before they issue them?
I guess what I would say is, I think working on this legislation has shown me that there's inconsistency. So to the extent that can be addressed through training, always a good thing. The legislature has sort of less ability to compel that. To the extent that maybe things need to be better delineated in statute so that the training and understanding flows from there, could be a benefit. Certainly there are state properties all over the state. You know, you've got buildings, we've got lands, we've got all sorts. I mean, every law enforcement agency, not every, but most would probably be implicated with a state facility within their jurisdiction. So it does seem to me that more information about this would be helpful. I mean, I think what's hard is we saw the numbers around the Capitol Police, and we know that it's not that many a year, you know, dozen at most kind of thing. But I don't know that there's any central way to understand how often this happens at the local level. And so that's where I don't really know the scale of like the problem, therefore how much training should happen, et cetera. If that addresses your question at all. But if there's no standard to train to, it's hard to train, I guess I would say.
Can I just?
Do you have a follow-up?
I do.
Go ahead.
It sounded like, in the testimony from our state police representative, that there are standards that they should be looking for, like that they should not just be issuing no trespassing orders if they don't legitimately believe that there is a cause for concern for harm from that person. You
Yeah,
can't, you
I
can't preempt it.
absolutely, and I quoted that in the first page of the memo, that the state police has said, this is our process for putting these out. That's not codified anywhere that I'm aware. I mean, it could be in a policy that the state police have, probably is, right? But it's not in state law. It's coming from case law. It's an interpretation, I think, of the case law. But other agencies that might give one of these orders don't necessarily have a place to go to say, here's my standard. And this is the process I need to follow.
Representative Henderson and then Sinclair. And then I'd like to just give the sponsor a moment to cover the last 4 bullet points when those 2 questions are done.
Thank you, Madam Chair. As we're talking standards, in your research on this, have you been able to flush out what exactly the standard is for a no trespass order? Like,
No.
okay, so more training on it wouldn't, like, we don't even know what the standard is at this point, it seems.
Well, I think what we know is the case law is pointing to those two questions, right, which were,
Are they present when they shouldn't be? And
is it open to the
justified?
public and is it justified, right? And so then the state police, what we've heard is they are answering that question by investigating, determining whether the person had a right to be on the property, right? That answers that question. And then, does their conduct justify a no trespassing order?
Right.
Right. And you know, I'm not in law enforcement, but I recognize that they have to make judgment calls all the time. And you could the committee could decide they want to put a finer point on that or not. But what's not clear to me is that this test is even being consistently applied across all law enforcement agencies for starters.
Representative Sinclair?
Thank you, Madam Chair. I was a little bit troubled by the major's testimony that the current process, such as it is, has been working for 100+ years. It feels to me that we don't really know that. What we know is that the process as it is applied, perhaps differently applied in different situations, has gotten us safely to this point. We don't know whether those folks who have been restricted for up to a year from a building they have a right to go to, we don't know what the outcomes are for them because we don't hear from them. Perhaps largely because they're not aware of the ADC process in the situations where it's available, or they simply can't afford it to go down that path. I'm wondering if it would thwart your intention at all for us to cap the duration of time, perhaps at 90 days, perhaps at a different number, cap the duration of time that a person can be ordered to stay away from that state property, and then require the state to apply if they wish to extend. I appreciated the majors admitting that most of the time people cool down and get over it. I understand he was suggesting that happens after a year. I haven't stayed mad for a year in my entire life, and I've gotten pretty mad at times. I think I usually cool down pretty well within a week, certainly within 3 months. So I guess I just wanted to put out there, I would rather see the onus on bringing the matter to court be on the party seeking to exclude the person that has a right to be in the building, rather than putting the onus on the party that's far less situated and far less capable of doing that. The state has attorneys, we know how to use them.
Yes, Eli.
I have a question for Representative Sinclair. So in the bill as drafted sort of contemplates the format that you're discussing, and the state going to court is in the form of the protection from harassment framework. Would that be the returning to court that you're thinking of, or some other forum?
Well, so we've identified a few challenges with using the PFH process. I just wanted to make sure we didn't go too far down the path of presuming that it would be the person defending their right to come to the public property having to pursue an ADC appeal. I didn't want us to go too far down that path and lose track of the focus of having actually it be the one seeking to exclude them.
Gotcha. Thank you.
Other questions? Representative Caruso, did you have a question?
No.
Okay. Senator, could you just take us through the last four?
Absolutely.
bullet
I
points?
just wanted to make a section that was sort of like other things that I want people to know that I heard that do need to be concerned. We need to be concerned with, but are sort of smaller issues compared to the question of that Representative Sinclair put forward. For instance, should the onus be on the restricted person in the state? Right now, it's on the restricted person. So do we want to deviate from that? So these other things are, I think it would warrant to clarify that a notice or communication doesn't include anything that results from court action. So if the court says we've gone through your due process and you have been noticed, you can't go to a place, we don't mean to like restart this whole process. So that's kind of technical. The second one was clarifying that the restricted person, that the order that restricts a person from accessing state property or services, to better clarify that what I meant by that was places or services where the general public has the ability to access. So I didn't mean to say that, I have a right to go into somebody's private office in the University of Maine system, and that the University of Maine system doesn't have a right to exclude somebody from a private office, right? So just make it really clear, places where anyone who's not restricted could go. So that's kind of technical, but I wanted to make sure everyone knew that was my goal. And then there was a question that came up in the public hearing around, if we do think this needs to be improved, because for government, should we consider extending it to other levels of government? So I want to make sure to have a holding place for that conversation, which feels way down the road from figuring out what's the next best step with this bill, but it's an important question. And then finally, the judicial branch made a lot of, I think, helpful points that were sort of more fine tuning, and some of them might or might not be applicable depending on how the bill is amended, but I want to make sure I didn't personally lose track of those. So that's kind of sort of the bucket of other things that are not germane specifically to the experience of the person receiving and then contesting the order.
Thank you. Questions for the sponsor on those last 4 points? Not seeing any right now. I guess I have one that I think is for the committee as a whole and potentially for the sponsor to comment on, which is so the bill itself asks us to establish procedures for restricting access to state property and services. And so it really is focused on, I know that there are other issues related to school boards and municipalities and counties, but I think if we try to maintain the focus on a state property, that we're going, it will be something that is more accomplishable than if we spread it over multiple titles of state law. So that would be one suggestion. It sounded to me from Major Stevenson, excuse me, the point that having an order that is issued by a local department and the case report sent to Capitol Police, and then Capitol Police review it to see if it is outside of the jurisdiction of the municipal department and then correct it. And he also referred to that as a process that worked. It seems to me like that's something that also is consistent with the issue that led Senator Grahowski to bring the bill to us. And I also think that it's consistent with the concerns we all have about due process and access to state services. There's a separate issue about, is this really just a question about was Ellsworth department properly trained? And that was raised by Representative Halloran, which I think is a really important issue, but I think it's maybe better treated as a subpart of Major Stevenson's concern that he raised about channeling these orders that involve state property to the state police. But I do think it's a really important point and could be addressed by creating that process. And then a number of committee members and the sponsor raised the issue about the importance of requiring a reason, the potential to include in the same piece of paper that has the reason, the fact that there is a potential ADC appeal. And then there were some concerns about the time frame and whether 1 year was too long, not long enough, and who has the onus for extending the order beyond whatever that given time frame is. And I would just share my reflections when I read the testimony from the University of Maine system and the implications for campus life, the obligation of the university under the Maine Human Rights Act and Title IX to ensure that students are not discriminated against in their access to public education. It made me really think more about the time frame and the need for a university to be able to protect a student for the duration of either an academic semester or an academic year. And that had shifted me to thinking about a longer time frame and thinking that a half of a year or a full year would be appropriate. So I'm sharing my thoughts with you, trying to think of a way that we can carve out a scope in which we're going to do our work. And so I will stop talking and would love to hear committee member or sponsor reactions, but I'm going to start with Eli.
I am just a brief interjection and an
Yes.
apology to Representative Poirier because I skipped verbalizing the answer to your question, though last week I did give you the answer. With respect to schools, there was a question in the public hearing about this language entity of the state and whether or not it did include public schools. It would not include any public school other than Maine's only magnet school, the School of Science and Mathematics, which in statute is a quote, a body politic and corporate and is an instrumentality and agency of the state. That would be the only school that this would contemplate. All the other public schools you think of, public schools, charter schools, those are at the municipal level of their kind of organization. That being said, the humane system is an entity of the state, would be covered by this. And so I know we talked about this last week, but I wanted to verbalize and not skip over that, even though I managed to earlier today.
Thank you. Thoughts, Representative Crusoe?
Thank you. Eli, and I'm sorry if I missed this somehow and I wasn't listening, but what about the Department of Corrections concerns about regarding prison? My notes were that the bill was broad and it would prohibit prisons from stopping drugs and contraband from being brought into a prison and restricting them from like when there's no contact.
Sure. I think that in terms of, I know that they testified to that point. I think there are representatives from the department here that could expand upon that. I'm not sure, from my reading of this, that limiting or changing a no trespass order would, it wouldn't make anything that is already illegal legal. It might change the tools or the timeline of things, but I think there are, even in those instances, other avenues in which they could prevent those sorts of things to happen. But certainly there are members of the department that can certainly expand upon their position.
I think somebody else had a hand up. Was it you, Representative Lee? No. Okay. Other committee member comments?
Senator Carney, if I might, just to your comment about the University of Maine system, I kind of skimmed through it, but I did flag on that second page of my memo a question about whether maybe it makes sense. I don't want to have a lot of carve outs per se, but does it make sense to have public higher education institutions be exempt from this process because they have these really specific other processes under state and federal law that establish due process where that's absent pretty much everywhere else. I had sort of skimmed over that, but I wanted to flag it since you had just made that comment that kind of made sense to me, that they're in their own process.
Yeah, and I think it would be interesting to see if what is is there within statute already a definition of the types of properties that you originally had in mind, the places where members of the public go to seek public services. Yeah. Yes, Representative Coons?
I just wanted to share, I think I would prefer to exempt the higher ed than extend the timeline substantially that applies to everyone in order to accommodate that unique situation.
Other thoughts, Representative O'Halloran? Your hand was up.
I had a curiosity question, but I don't know if it's appropriate.
Why don't you ask it? And if it
Okay.
takes us out of the scope of the bill, I hope you won't mind if I say so.
No, that's, I'm used to that. So I don't mean that in a bad way. I'm just saying. We need one, yes. what are the repercussions for the police department that issued this that was in violation of her rights? And is it only achieved by her going to court against them?
I think that's outside of the scope because it is an issue of whether the person has a legal claim and how would they bring it. And this is more about changing the process. Thank you for asking it, though. Do people have other thoughts about how to define the scope of what we might want to work on with regard to this legislation? Representative Henderson?
Thank you, Madam Chair. Maybe not so much putting like clear-cut definitions, but I think the sponsor actually did a really good job. This is the first time I've ever sat through a work session where the bill sponsor has asked us a bunch of questions. So that was kind of neat. It was a unique way to approach it, but I appreciate it very much. But it seems as though the objective, or at least the path forward that I'm viewing, is two separate processes, which is the short-term, immediate, remove the potential threat, but do it in a way that is not restricting people's First Amendment rights and not trampling on their First Amendment rights to be able to have access to their government. But then also creating maybe the more extended portion that would require some type of a court process or a judicial process where there's fact finding and there's a due process for the individual. Am I understanding that correctly, or has everyone else kind of moved on to a different train? Like that we're trying to establish a short-term process as well as an extended process for scenarios where maybe someone is threatening or they're potentially unsafe.
Representative Lee?
Yeah. I think of it as a two-part thing as well, because I think of it slightly differently. I think of it as notice, right? And there's a lot of things that we've talked about that we can do on the notice component of this. And then the secondary process thing. And I've spent so much time thinking about the PFH process, and it's just not the right process. And I also like the idea, though, that the state should have to do something after some period of time. And I brought up the main court rules because I was going to ADC, and then I was like, there's ADA, B, C, blah, 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 blah. And a lot of those are just summary proceedings. And some of them are for like the issuance of a search warrant. Some of them are in 80K, for instance, is for land use violations. And it's ways to usually a government going to court to do something in a summary way. And it feels like, we can't change the rules of procedure, but it seems like something like that, a summary process where the state would have to go to court to prove that the conditions are still existent to justify the no trespass order after a certain period of time is the best thing we could do.
Going to raise a note of caution, which is that the more we build on the current process with minimal additional needs for fiscal expenditures, the more likely this would be to become law. And the more we expand the process, the more we're going to have concerns with who's going to do the work, who's going to pay for the work, and including if we created a new kind of court procedure, is that something that the judicial branch could absorb at this time? Because we've got lots of court procedures that have been waiting for funding for several years they just keep coming back on the appropriations table. And so I'm just a little reluctant to think elaborately rather than just trying to think efficiently. So I'll just add that note of caution. But it sounds like there's an agreement as to scope, I would say, that we're just talking about state property where people get public services, that we care a lot about notice. We want suggestions for duration and then how to utilize an already existing appellate process. And maybe we can ask the sponsor to work in that direction I know that's a lot less elaborate than you, Representative Henderson, and you, Representative Lee, were talking about, but I also think that we have to be realistic about how much our currently overwhelmed system can absorb by way of additional processes. Yes, Representative Henderson?
Thank you. This isn't fully thought out, so you guys are getting just raw thoughts as they come to me, but I don't know whose perspective here I'm actually agreeing with more, as much as maybe a hybrid of the two, right? So we would have a short term, my way I envision it would be the short term, no trespass that isn't just around this kind of gray area of justification, but actually has some clear cut, whether it's threatening language, something that determined an imminent threat that individual needs to be removed. Not just harassing language or they show up twice a day, but heightened direction around what is justified, specifically for state entities.
Can I just raise a note of caution? So you're basically tinkering with the standard that the law court set about the conditions under which a no trespass order could be upheld. I'm just saying that as a.
Can you flush that out a little bit?
Maybe, but I think let me go to Eli's bill analysis. And this is what I'm thinking. And perhaps this is not the appropriate way to think about it, but there was Eli, what's could you refresh us about the law court case?
Sure. The law court case was, it was named in the testimony of the state police. It was State v. I believe McDonald. Mark Anthony, my apologies. State v. Mark Anthony. That was a 2002 case. Really, what came about with that case was that there needs to be an articulable reason for the no trespass. The situation was Mr. Anthony was trespassed from the University of New England, and a year or two later, he went back under the guise of trying to figure out why he wasn't allowed. And there really was this misunderstanding of why he was not allowed there in the first place, even with that order still standing. And so what came about with that law court case is that when you issue these notices, there needs to be some sort of justification for it. Whether that is, I know one of the things that this bill is contemplating is whether that justification is communicated to the person or not. I think that's a bit nebulous. To your point, Representative, about justification or reason in that, and this is on page 5 of your packet in front of you, in that cease harassment statute, the basis of a lot of this is, you'll see there 1A, the person engages in any course of conduct with the intent to harass, torment, or threaten another person. And then we get into the having been notified in writing or otherwise not to engage in such conduct. And so the cease harassment order that you see by the state police is basing off of that harassment. So that is the notification from state police to a person who is presumably harassing, tormenting, or threatening another person. And so those points, all those words all have definitions and kind of expand beyond there. But I think that is the scope that the state police operates under right now, is in terms of harassment, and the justification is, are they doing one of those things?
But it's my understanding that's under harassment, not under the no trespass. Right?
Right.
So if the law court stated that we need to be specific, or law enforcement need to be specific around the justifications, I'm not seeing anywhere in our state law where there are specific actions that determine justification. And I think that is, I'm sorry, but I think that is kind of what I'm getting at, is when we're going to restrict a taxpayer from publicly accessible spaces, that there should be a heightened level of activity that constitutes a no trespass.
And I'm not agreeing or disagreeing with you. I'm just saying that would be a big shift, because right now the analysis that a law enforcement officer goes through for the no trespass is whether the conduct justifies the order. And to begin to articulate specific criteria is just going to be, I mean, I'm not advocating one way or another. I'm just going back to the principle that the more we modify existing law and procedure, and maybe we want to do like a big change, but the more we make that change, the more expense and time and technical concerns we're going to have to confront in the process of getting it passed through the bodies. That's all. But I'm wondering if the sponsor would like additional direction from the committee and also committee members. I feel like I've kind of been monopolizing this conversation. So if you have other things
I've been monopolizing the conversation.
other things that you wish to share with the sponsor, let's do that now. And then we'll complete the work session and have the sponsor bring us back an amendment to consider likely next week. Yes, Representative Crusoe.
Thank you. This is all very good conversation. I had two thoughts. One is for your sponsor. Have you had conversations with local law enforcement? Do we have testimony from local law enforcement? Okay. And then have you
I'll just be honest that the information, like when I went down this rabbit hole, which you're now all in with me, thank you. I knew that Ellsworth PD had given this order to my constituent. It only became recently in my awareness that the state police / Capitol Police didn't know about it. So I hadn't gone down that path because it's only been kind of a recent revelation about that sort of disconnect.
And I'm just gonna bring it up again with the Maine State Prison and the POC and their concerns in their letter. We haven't heard from them. I know you said, Eli, that you don't think it applies. Have you had that conversation and that's kind of their concerns are now neutralized?
I would say thank you for the question. I went back and reread their testimony. I haven't since spoken with them. I do think Eli brought up the salient point, which stuck out to me when listening to the testimony, which is, I gave it to you, I think. Or did I give it to you?
They're not
Gave it
open
back.
to the public. That's the only thing I can think of, but
The public can go in and say, I want to talk to a person, right? There's a process
there is problem.
for a person to visit with an incarcerated person. So there is some public access. Sure, I can't show up and say, take me to this, the gym, right? I'm just thinking of a space that exists.
The other thing.
But my point is, what I want to say is all of these examples that were in the DOC testimony are all things that are illegal. There is an existing mechanism in the law to deal with, for instance, somebody who's bringing illegal drugs into prison. You don't need to use a no trespass order to deal with that because that's illegal. You don't need a no trespass order to deal with the example of no contact orders. No contact orders come from the courts. So in my view, this bill doesn't apply to those, right? Because there's been due process had. So I found that they had a lot of interesting examples. And then when I sort of parsed them out, I thought these are all already covered through existing judicial processes.
Yeah, so just to
Another item on their testimony about the DOC having to rely on the state police to go to court on behalf of the DOC.
Yeah, I'd flagged that as, I think, one of the things, I think I flagged it in the memo. I had maybe misunderstood a previous conversation with the state police. I had thought they were requesting that they wanted to be the point person to initiate that contact. Their testimony said, we don't want to be that person. So I would propose to change that. Certainly every agency, maybe just leave it up to the agency. There's an attorney general's office that works on behalf of the agencies in the judicial system. So I think And some of them have their own lawyers, so maybe letting them decide, do we want to use our own DHHS lawyer? Do we want to ask the AG's office? But that part I've sort of moved on from, and I may not have said that earlier, and I apologize because if the state police don't think they're the right entity, then I have no reason to think that they are. So that's fine.
So Representative Caruso, are you thinking that Senator Grohowski should consult with the representative from the Department of Corrections, Jill O'Brien, who's here today, and try to work through whether they would be exempted or included and what the value is of the no trespass to them?
I do. Thank you, Senator.
Yeah.
Either she comes here and says, oh, I changed my mind. I don't think this is an issue, or sponsor kind of works this through.
Mhm.
She is an attorney, and I think we need to listen to what they have to say before we pass something that doesn't work.
Great, thank you. Thank you for raising those issues. Anything else, committee members? Not seeing anything. Are we ready to end the work session? Would somebody like to make a motion to table? Representative Kuhn?
Thank you. I'll move to table.
Is there a second? Seconded by Representative Poirier. All those in favor? And that is unanimous of those present. So we'll close the work session on 2150. Thank you, everyone, and we will let you know when this will be rescheduled. Committee members, let's take a break until 2:45 before we start our work on the parole bill. And that is LD 1941. Committee members, if everybody could please return to the horseshoe, we'll get started on our next work session. So we're going to open up the work session on LD 1941. This is an act to implement recommendations of the commission to examine reestablishing parole. Eli is going to orient us. And the bill sponsor is here as well, and we'll start there and then take our next steps.
Great.
Actually, I just realized that some of our colleagues may be caucusing, and I don't want to start the committee without them to respect their need to converse with each other. So let's just wait a moment. Okay, so thank you, everyone. We're going to get started on the work session on LD 1941, an act to implement recommendations of the commission to examine reestablishing parole. And Eli, if you could orient us, please.
Sure. So on the 28th, we had an initial work session on this bill where I presented the bill analysis, and you have in your packets, you should have a pretty lengthy bit of information, some of which is data requested, some of which was the portion of the parole commission's report at which this recommendation kind of came from. And you heard a lot about how we got to where we are now. At that time, an amendment was presented by the sponsor based on some of the amendments requested at the public hearing, as well as work that she had done since then. After the course of that work session, the committee discussed and thought that there might be more things that needed tweaking and working on. At that point, you tabled it for more work on that amendment. Soupy should have passed out to you a new yellow amendment that says, I apologize, I don't have a date on it, but it is the yellow amendment you should have there on your desks. A couple of things that I will go through, and then I think I might toss it over to Representative Lee if you want to kind of go through it. A couple of changes. If you go to pages 10 and 11, there's a couple of things that I missed in preparing this, or it might have been a formatting thing. On page 10, subsection 5, parole revocation hearing, you see on the third line there, it says 34. The 4 should be crossed out, so it's under subsection 3. And then the second change is on page 11. I missed striking out a piece. If you go halfway down the page on paragraph C, it says the parolee's efforts to comply with any sanctions. You should strike imposed under section 5827, subsection 1 for a technical violation of a condition of parole. And then the language continues and with any modified, etc. So those
I'm
are some
sorry,
initial-
Eli, I wasn't following you. Can you just tell us where we start striking and then
Sure.
where we end striking?
And Representative Lee has raised his hand, so I want him to confirm that that is the case. I believe it is. So on paragraph C, it should read the parolee's efforts to comply with any sanctions, and then you are going to strike imposed under section 5827, subsection 1 for a technical violation of a condition of parole. And then it will continue and with any modified, et cetera.
It should read any sanctions and any modified conditions.
Yes, correct.
Thank you. Everybody got that? Representative Lee?
One other sort of just technical thing I noticed earlier this afternoon is on page 1. Under 5202 subsection 3. Beginning on the effective date of this subsection, from the comma to that should also be struck, because that portion of that sentence doesn't make any sense with the deletions that were made.
So it should read beginning on the effective date of this subsection, comma, at least one member.
Yes, comma, and then that should be a lowercase a.
Thank you. Everybody got that? Oh,
Sorry,
okay.
I'm not following. Can you read how it should read?
Yeah, so it should read beginning on the effective date of this subsection. And then you should go all the way down to at least.
Gotcha. Thank you.
Senator Hagan? What's that? Okay. All right. Eli, anything else?
Nothing from me. I think that Representative Lee was going to take the stab at going through it, and then I can answer questions as we go through.
Thank you. And I know the bill sponsors here, as I noted earlier, and we'll call you up after we get the review of the proposed amendment from Representative Lee. So Representative Lee, the floor is yours.
Sure, I'll sort of go through it. A lot of what we have in here are changes that Representative Milliken already discussed with us at the first work session, but I'll go through the additional ones that I've made. The first one on page 1 is the addition of the appointment of an executive director for the parole board. It seems like the amount of work that the parole board would need to do is sufficiently large that you would want someone who's administering that. I've also, you'll see later on, I've left to the board a lot of their ability to create their own criteria and factors to evaluate. And it seems like that would be heavily aided by having an executive director there who's not one of the people who's going to be voting on those. And so that's a fairly large addition. Then on page 3, rather than using the actuarial evidence-based risk assessment, which seemed to me to be kind of overly prescriptive of what the factors are going to be evaluated by the board, I've done this comprehensive assessment of risk and suitability that's a lot more open to development of factors by the board itself for its evaluation. And that changes in a lot of places because the actuarial risk assessment was throughout. On page 4, we've defined parole plan because that was a phrase that was used regarding the application, but it wasn't defined anywhere. And so I think defining it was a good idea. Then I think kind of the biggest change in this document is, well, I guess that's subjective, but a change that was made in the document at 5823 sub 1 is it's sort of a split process. So for any sentencing that occurs after the effective date of this bill, you would need a majority of the board to vote for parole. But as to convictions after 1976, which is the date of the repeal of parole, to the date of the effective date of the legislation. So essentially those sentences that have already occurred where there are people already in prison, you would need an additional member of the parole board to vote for parole. So you'd need essentially a supermajority of 5 of the 7 members to vote for parole. Moving on, pages 5 through 6 outlined a lot of process and procedure stuff. And so I didn't want to create the wheel here. And so rather than having complexities in the way that the procedure works for a parole hearing, I've largely said that the Administrative Procedures Act applies, which we do in a lot of our statutes when it comes to these type of hearings, unless the procedure outlines something else. Then you have the guidelines again, replacing comprehensive assessment of risk and stability for actuarial evidence-based risk assessment.
What page are you referring to?
I'm sorry, on page 7.
Thank you.
And then 8. It's the same for that. On page 9, in subsections 4 and 5, that's just that deletion makes it consistent with the deletion of the actuarial evidence. In 5827 on that same page, page 9, there was, and these are for violations of conditions of parole. Previously, there was a way of treating technical violations as distinct from, I guess, substantive violations. I got rid of that distinction because I just don't think a violation of parole is a violation of parole, irrespective of whether one might consider it technical or substantive. So I've gotten rid of that, and that's mirrored in a lot of the changes after that. I've again deleted a bunch of process and procedure stuff that is distinct from the APA. So just applying the Administrative Procedures Act instead of outlining a new procedure. You have another substitution on revocation hearings of that comprehensive assessment of risk and stability versus the actuarial evidence. And that pretty much summarizes the changes that I made in addition to Representative Milliken's changes.
Thank you very much. Okay, we're going to start with questions for Representative Lee and or for Eli with regard to Representative Lee's draft. But Representative Lee, a question for you initially, which is because we also want to hear from the sponsor, but did the sponsor just receive this at this work session, or did she have your changes earlier?
She had my changes earlier and reviewed them, and I think agrees with those changes, but I won't speak for her.
All right, thank you. Okay, so committee members, questions for Representative Lee? Yes.
Thank you, Madam Chair, and thank you for all the work that you've put in with the sponsor to draft this amendment. I just want to go back to the change between the actuarial evidence-based risk assessment to the comprehensive assessment of risk and suitability. Because I'm noticing that one of the big changes is that we've taken out that a requirement that the board shall consult with the Permanent Commission on the status of racial, indigenous, and tribal populations about racial bias.
Yep.
Can you speak to why that was not added back into your other parts?
Yeah, that is incorporated into sort of the evidence-based standards of today. They consider those things like race bias. And so that's another reason why I wanted to have an executive director, because I think that that person can inform those trainings, which also include things like race bias. And so I didn't think there needed to be a direct consultation of another entity in doing that.
Other questions? Questions for Eli? Eli, I have a question for you. Are you able to comment on the adequacy of substituting the Administrative Procedures Act for the process that was in the bill as originally proposed? Is it the appropriate level of process including safeguards, obviously, but also including usability by persons who would apply for parole.
I think specifically to that last question, I'm not sure. I mean, it's given that this is a new, it would be a new procedure, there's no kind of baseline avenue that people are thinking, oh, this is how I do it. No, actually, you do it this way. And so I think if in the implementation, it was clear that this is the avenue in which you do this, then it would certainly be fine. In terms of the adequacy of the process, I think as Representative Lee mentioned, just going based on the APA guidelines and rules is a lot of our functions in the courts default to that versus setting up their own, oftentimes fairly identical procedures. And so I think from that standpoint, it's fine. I don't know if there's further clarification you want beyond that.
Maybe I'll ask Representative Lee a similar question. Can you just walk us through what that process would be like for somebody who has submitted an application for parole?
So the places, I'll start with the places where it somewhat deviates. So it does set up in the preliminary review.
I would just say that if you can assume that you and Eli are the only people around the horseshoe who have familiarity with the
Yep.
Administrative Procedures Act
Sure.
in articulating your description. Thank you.
Sure. It's not as formal as, say, the rules of evidence are in a courtroom. You can use evidence that is, I can't remember the phrase. It's something to the effect of as would in common. God, do you remember the phrase in the APA?
As people would ordinarily rely on in the conduct of business or their reasonable day-to-day affairs, something like that.
Yeah, so you can use evidence that you wouldn't necessarily need to submit in a courtroom. It's much more usable for folks who are not legally trained or legally educated. There's some deadlines within it that are assumed to exist that rather than having to make things up, they already exist in it. I mean, I think that the component and the reason that I chose the APA over other more formal processes is that it sort of presumes that someone who doesn't have a lawyer could go through it on their own. And you don't need formality to the process.
You give us a, for instance, of a process that the ordinary person would be able to navigate that relies on the Administrative Procedure Act, just so that we can wrap our minds around it?
A professional licensing board is the example that I'd most have in my head, is that, a person who, say, has a business license that's about to get suspended would be able to go and present sheets of paper or their thoughts without having to be questioned and answered, would be able to present all of that on their own. And so in a parole board hearing, I assume if a prisoner is not themselves defended, that they would be able to navigate that process far better than a formal court proceeding.
Thank you. Thank you for answering all my questions. Other questions, comments, Representative Sinclair?
This question is to Representative Lee. Were there financial considerations that went into the proposed adoption of ADC as a path rather than a criminal process? Was it intentional that these individuals might not have the right to appointed counsel? Or is that an unfortunate byproduct, or do you think neither?
I think I began from the assumption that they would not be necessarily entitled to an attorney, a paid for attorney. And so I operated from that assumption in constructing it the way that I did. I don't know if I'm correct about that, though.
Representative Sinclair, do you have a comment on whether or not they would be entitled to counsel under the Sixth Amendment?
Thank you, Madam Chair. I would just note quickly that in revocation of probation situations, they certainly have a right to the appointment of counsel. We're talking about the potential deprivation of a liberty interest that the person at that point enjoyed. So I believe they would have a right, but frankly, they only have a right if we declare it or if the law court later says you guys screwed up by not declaring it.
Representative Lee?
Yeah, and I wasn't thinking about the revocation context. That's an interesting thing. I don't think you would have one in the original application for parole, but in the revocation proceedings, you're probably correct that I think that one would at least have an argument that they're entitled to an attorney in those instances.
Representative Kuhn?
Thank you. I'm sorry if I missed this on the first time through, but I didn't hear it. On page 10, under, and the toner on this copy is such that I'm having a hard time telling like what is crossed out and what's not. But it appears to me under paragraph 6, hearing procedure, like the standard is changed from clear and convincing to a preponderance of the clear and convincing. Am I?
That was a change with the initial amendment brought forward by the sponsor, was to change it from the printed bill, which had clear and convincing, to a preponderance of the evidence. I think this new amendment would strike out the hearing procedure as well in favor of whatever the APA has as.
I see.
Yes.
Okay. Thank you. Great.
Additional questions, committee members? Would the committee members like to hear from the bill sponsor? Thank you. Representative, could you please join us?
Hi.
Thank you, Representative
Good
Milliken.
afternoon, everybody. Nina Milliken, Bluefield, state rep. Are there specific questions you want to respond to or?
Yes, let's let committee members ask you specific questions. Committee members, questions for the sponsor, and Representative Lee, do you want to ask the first one?
Yes. How'd I do?
You did a good job. Thank you very much for your work, Representative Lee. I appreciate
More to the point, do you agree with the amendment?
Yeah, I'm happy with this amendment.
Additional questions, committee members? Yes, Representative Poirier.
Thank you, Madam Chair, and I'm not sure if you can answer this off the top of your head or if you might have to try to figure it out, but I'm trying to get real life examples of what would happen if this goes through. So for instance, if somebody is convicted and sentenced to 25 years, at what point are they eligible for parole? How long do they technically have to serve?
Yeah. So if a person is sentenced to serve a period of 25 years incarceration, they would have to serve 50% of that sentence, half of it, so 12 and a half.
Can you just talk a little more slowly? Thank you.
If a person is sentenced to 25 years period of incarceration, based on the bill, they would have to serve 12 and a half years of that incarceration before they were eligible to apply. And then they would have to meet a list of criteria in order to apply, in addition to having served half of the sentence.
Follow up.
Yes.
And with that, so we're saying 12 and a half years, do they also get good time off of that?
So my understanding of good time is that it's, I guess I'm not the expert on good time and I would defer that question to perhaps the Department of
So
Corrections.
say if they did, it could potentially be a 25-year sentence that maybe they're only serving like 10? Ballpark figure sake, you know?
I don't feel prepared to, I guess, to ask that question right off the bat.
Thanks.
Yeah.
Additional questions, committee members? The question for you. One of the concerns that I have is with regard to retroactivity, because I feel like there are settled expectations and predictability that would be upended by retroactivity.
Yes.
And so I'm just wondering if you can comment on why you think retroactivity is appropriate and whether you would be opposed to a bill if it was only prospective.
Yeah, I personally, obviously, based on the bill that I presented to this committee, my strong and heartfelt preference would be that the bill include a provision for retroactivity. And I'm very grateful to Representative Lee for trying to thread the needle or come to some kind of compromise that allows for retroactive application to people currently incarcerated. there are a lot of reasons that I think retroactivity is important, and I spoke to some of them in my presentation of the bill. One is that this committee has done some really good work, and I think we as a society have done good work in changing sentencing guidelines and how we talk about certain crimes. A really easy example off the top of my head is cannabis. 20 years ago, cannabis was criminal. Use of cannabis was a criminal thing, and at this point in time, it's not. And so when we have a change in what we see as criminal versus not criminal, or what we see, what this committee has decided to change in terms of sentencing guidelines or how we talk about sentencing, when that changes, in my mind, there should be consideration of people who are currently incarcerated under the guidelines that we now see as less just. There are a lot of people in our Department of Corrections system right now who I think would have been sentenced to different, like judges likely would have made different considerations if they had been sentenced today than when they were sentenced many years ago. And that a very good example is that I had a prosecutor who flatly told me that had we known today had we known in early 2000s when these men were sentenced, what we know now, they never would have gotten the sentence they received. And the fact that we have no mechanism in current law in this state to adequately address what I see as a serious injustice in that situation leads me to believe that we should have some mechanism to look back at the sentences that we've doled out since some of the changes that this committee has made and since some of the changes that we as societies and communities have made. Would I support a bill going forward that only looks at prospective cases? That would be a hard thing for me to do personally. My heart is with a lot of the people who I think deserve reconsideration of their sentences who are currently incarcerated. It would be hard for me to vote against that bill, Senator Carney, but I understand that's a decision this committee has to make, and it would be challenging for me to support a bill that didn't work retroactively, but.
Thank you. Other questions, committee members? Yes, Representative Lee.
If we made an additional amendment to the bill and it would be on page 5 of the amendment, to make sure that calculation of 50% or half of the sentence has been served, not including good time. I don't know what the language is, but I'm sure Eli can find the language that we would put to make sure that good time does not go as part of that calculation. Would you agree to that?
I think that would be fine. Could I just respond add one more thing to my previous response to Senator Carney? That'd be okay.
Yes, because I actually have a follow-up for you too, so go ahead. And thank you for the question.
At a
Representative Lee.
minimum, what I would beg the committee to consider is some mechanism to look back, give a second look at people who are currently incarcerated, to perhaps ask judges to say if these folks were sentenced since we have changed sentencing guidelines, or since just some kind of consideration for a second look as an amendment. I think that would be helpful to me personally. So
thank you. And can I, you had referenced in response to my earlier questions of you, the difference between how we look at things now versus in the early 2000s. Can you articulate what that difference is, please?
Well, just an easy example, because it comes right to mind, is last year, this committee determined that judges should consider the defendant's age when determining sentences. And that wasn't something that we would have considered in 2009. The case that I referenced before, where the prosecutor told me that we wouldn't have sentenced these men to the same sentence that we did back in the early 2000s. The men who were sentenced were 18 and 19 years old when they committed the crime that they're now in prison for. And one of them was 2 weeks after their 18th birthday. We've learned a lot about racial bias in sentencing in that time. So I just think I know that this committee has made other changes in the last 50, 60, 70 years around sentencing and what judges should be considering in determining what a sentence should be. So does that answer the question?
It does. Thank you very much. Other questions for the bill sponsor committee members? Yes, Representative.
Are there any crimes or types of, I'll just say murders, like some that are particularly more egregious that you don't feel should be allowed?
Could you
Yeah,
ask your
for
question a
parole.
little bit louder? I'm
Oh, sorry. Are there any crimes that you do not feel that should be up for parole? And if we're talking murder, are there any types of murder that you think should be excluded from being eligible for applying for parole?
I appreciate the question. I don't think there should be any crimes that are excluded. I think that every person has the ability to be redeemed and to be rehabilitated. And I also think, I know, and I don't have the data right in front of me, but I'm happy to get it to you, that some of the crimes that we as a society view as like amongst the most egregious, like homicide, the people who commit those offenses are the least likely to reoffend. So I come from a place of like, I'm a pretty data-driven person, and when I saw that data, I was compelled by that to say that it should be open to all people who have been convicted of crimes. And also, I would just say that broadly, and I think I said this in either the last work session or in the presentation of the bill, parole boards broadly are very conservative and tend to err on the side of caution. And the baked in requirements for application for parole are quite stringent. They align with the ones that are required for the supervised community confinement program. So I hope that answers your, I wouldn't exclude personally any crimes, but yeah.
Other questions, committee members? Representative Sato?
Thank you, Madam Chair. And thank you for being here today, Representative Milliken. I'm looking at section 5202, appointment on the first page, just to go back to the racial bias aspect of taking it into assessment. Do you, in your opinion, do you think that the term up-to-date best evidence-based practices in the fields of parole evaluations and assessments will in real life implementation include racial bias evaluations, or do you think there is an option here to specify these assessments to ensure that we actually are doing them here in Maine?
I am open to and would be happy to have the bill further amended to explicitly require that expectation, I guess. So did that answer the question? Okay. And I appreciate the concern.
Additional questions, committee members? Yes, Representative Caruso?
Thank you, Representative. It just struck me, your answer to Representative O'Halloran about people who've committed murder, that they have like a less likelihood of doing that. I was just wondering how that data comes about. If they're in jail, that would make it more likely that they couldn't commit murder?
I would have to look at the data, but yeah, it's a valid point taken.
Oh.
Yeah, I can get you some information.
Representative O'Halloran?
Thank you. Representative Sato's question kind of got me thinking. Because it should be the person, their work, the crime, not necessarily their skin color that should determine whether or not they should be looked at for parole. So if we were to specifically add that, do you think that would put other people at a disadvantage?
So my understanding of what Representative Sato's question is trying to get at the fact that we all have racial bias, right? We all come from a position of even unintentional racial bias. And sometimes when parole boards and sentencing judges determine whether or not someone should be paroled, let's just use parole boards, there is bias, often racial bias, in making those determinations. And so my understanding of Representative Sato's question is whether or not we should explicitly require that the parole boards have some kind of training, and correct me if I'm wrong, Representative Sato, to try to, as best we can, eliminate that racial bias from the parole board in determining whether or not a person should be paroled, not whether or not we should give preferential treatment to people of color, but to try to eliminate the bias that might otherwise perhaps it would be present in a parole board's decision making. Does that make sense?
It does, but it does.
Additional questions, Representative Sato?
Perhaps I could clarify a little bit where I was coming from. I think where I'm coming from is in the original amendment we were provided by the sponsor that was about, as a reference, section 5826 parole guidelines, subsection 2, about the actuarial evidence-based risk assessment. There was language included in that would require the board to consult with the permanent commission on the status of racial, indigenous and child populations, with the intent to give due regard to the racial bias inherent in many extant assessments. And so the idea being, I think here was to include that as a factor when assessing risk and suitability, which we are which Representative Lee has wonderfully reworded in a different way. So I just want to make sure that while we are rewording it, that the racial bias inherent is still included in those considerations.
You may.
And I understand that, but my understanding was that that is already supposed to be part of the requirement. So that's why I asked, but I appreciate where you're coming from. Thank you.
Additional questions for the sponsor, for Representative Lee? Yes, Representative Kuhn.
Thank you. I'm trying to think about the amount of time served prior to eligibility. And we had a third, Representative Lee has a half, other people have mentioned 2/3. Did we get guidance from other states perhaps? Is there a standard quantity that we could refer to as established in law elsewhere?
I didn't look at other states prior to this, but I would just want to steal credit for a second away from Representative Lee. I said a half. That was my amendment. I don't have a data in front of me about what other states are using, but I think half is pretty standard, from my understanding.
So the half was, as Representative Milken said, the half was there included in this amendment are both the changes that you saw last week as well as the additions from Representative Lee. I don't have data for other states. However, when Maine did have parole prior to 76, half was the eligibility standard that we used. And some of that information is contained in your blue packets in the portion of the report that I included.
Thank you, everyone. Other questions, Representative Lee?
Not a question. I was just going to indicate that the place where I would suggest we add Representative Sato's suggestion is in the executive director appointment portion on page 1. So after up-to-date best evidence-based practices in the fields of parole evaluations and assessments, including inherent race bias. So essentially in that best evidence practices, they would learn about inherent race bias. My cursory review of what those best evidence practices are right now is that they include education about inherent race bias, but just to make sure that it gets in there.
Other questions, committee? I have another question for you. So in some of the work that we've done with regard to domestic violence and homicides in the context of domestic violence, we've heard from the commission related to domestic violence homicide that when the woman in a relationship is charged with killing the man in the relationship, that woman is frequently treated much more harshly by the criminal justice system than the man. And so I'm wondering, I guess this is a question for you and also for Representative Lee, like, do we want to specifically call out inherent racial bias, or do we want to think about inherent bias more globally? Because I think that, that's an important consideration for me.
I'd be perfectly comfortable removing racial and just saying inherent bias.
And while we're there, many of the women who are charged with those types of homicides are victims of abuse themselves, and I think deserve some consideration and retroactivity.
Yeah, that's what we learned in our work over the past couple of years as well. Thank you.
Can I just add that I know this committee knows I go to Maine State Prison often. I also have gone to MCC many times. It's a much more emotional experience for me to go to Maine Correctional Center, and I have a harder time doing it personally just because of many of the women that I see in the facility are women I identify very closely with. So as a mother, as a person who uses drugs, and as a person who's a victim of domestic violence and sexual violence myself, it's very challenging for me to go into that facility sometimes. So I encourage you all to go if you haven't been before. So
Thank you for sharing that information. Other questions, committee members? Is there anyone else committee members wish to hear from, or would committee members like to take a caucus break? Okay, so thank you very much. Representative O'Halloran has a question for the Maine Prosecutors Association.
Shire Burns, Maine Prosecutors Association.
Thank you for joining us.
Thank you.
Go ahead, Representative.
Thank you. How do you see, do we have the ability to implement this program in I'm certain that's a piece that I'm really struggling with on it, like financially and how this is all even going to work. Because my understanding, the sentencing that people have been receiving since 1976 kind of takes into the fact that we eliminated parole. It's like up to a certain amount of years. Like, how is all that going to play out?
So one of the like big things that we discussed about this bill, and again, nothing about policy, but just like the practical implementation of it, is how this bill will coexist with probation as it is. So if you follow the Huey analysis, that's the 3-step process to sentence somebody. The 3rd step is once you have what's called the maximum sentence, step 2 of how they're sentenced, let's say it's 10 years, the judge determines what part of that will be suspended. And with that comes a term of probation. So when I see this bill, what would happen if it was implemented with no changing to our sentencing structure, is that somebody could be out on parole and at the same time get a probation violation. And so we're having a court hearing and doing the probation violation with a judge determining what the response will be to that violation. And the same time, a parole hearing with another body deciding what the repercussions will be. And that's because people can violate their probation before they're even like in the community out on probation. So they could do it while they're incarcerated. They could do it while they're out on parole. So the person is in the community on parole, contacts their victim. We will file a motion to revoke probation, have a whole court proceeding on it. But this bill in the same time would have this other proceeding going on.
Thank you. Other questions for Shira Burns? Yes, Representative Lee.
Oh, no, I have a question for Shira, but Representative Milliken just informed me and reminded me that I had actually already made the racial bias change. And so rather than putting it in that initial section, I have it on page 7 in the parole guidelines. And so 5826 sub 1, it says such guidelines shall give due regard to the racial bias inherent in parole assessments. And so I would have racial and gender bias inherent in parole assessments instead of adding it in the first section.
And you said you were in section 1 of 5826?
Yep.
Okay. I see. Thank you. Yes, Representative Kuhn?
Alternatively, could you remove racial and just leave bias? And that way we're not trying to identify every possible class of bias.
Absolutely.
Thank you both. Yes, go ahead, Representative O'Halloran.
Could you, just so there's a broader understanding of the exact differences of between probation and parole?
So parole is whatever you say it's gonna be, the legislature. Probation, as it stands now, we have a whole probation system. So that, and DOC probably could do a better job, they oversee probation, is because we have this Huey analysis with this step 3 of people being released, while still serving their sentence. So it's always called a split sentence, not always, if they have a split sentence, 10 years, all but 5 with 4 years probation. That would be a very common sentence. Well, maybe not that many years, but like a split sentence like that. And so we would say 10-5-4. Well, what does that mean? It means that they actually go to jail, prison for 5 years. They get released after 5 years, and they have 5 years hanging over their head because 10 times 5 is 5. So when they're going to be out in the community for 4 years on probation, and if they mess up, they have 5 years hanging over their head that they could go at the maximum back during that time. So probation will oversee the time they spend in the community while they're still serving a sentence. And very specific probation conditions. Obviously, a very common probation condition is with any victim of crime is a no contact order. People contact their victims in jail, in the prison. And so you can file, and we do file, motions to revoke their probation while the person's incarcerated because they are violating their probation conditions of no contact. And then we have the probation violation hearing where the judge would usually add on time of their suspended portion to their sentence. And so if you put this together with the bill in front of you, you have somebody that is serving their sentence. I think, let's say it's 10, all but 5. They get out on parole earlier, and they're still under the probation conditions, because they will be, because nothing of this bill touched our probation statute or sentencing statute. So while they're out on parole, they contact their victim, and we literally have a full court process dealing with that, when this bill at the same time would have a parole process dealing with that.
Thank you.
Representative Kuhn?
Thank you. So it seems to me that situation could be addressed by removing the retroactivity, because presumably going forward, sentences would be differently structured.
So and this is, we were talking about this because these bills don't touch the sentencing at all. So if this bill went into effect, even just forward, nothing in this bill tells judges to do anything differently. We'll be doing them by statute. We have to follow the Huey analysis, and we'll be doing them exactly the same.
Representative Caruso?
So this is helpful. It just shows a conflict with laws, and it seems like the only way this could ever not conflict with probation is if we got rid of probation or completely changed. I'm not saying I'm advocating for that, but I'm saying right now, there's a conflict. There's gonna be a conflict in the courts. We'd have parallel proceedings going on. It would be a mess. And the only way, if it's either one or the other, or are there states that have both?
I don't want to talk about, I don't know what other states do. I know if people talk about probation, parole, I'm sure they can somehow coexist. I'm just saying this bill doesn't touch it, and it will cause a problem unless our sentencing structure is looked at as part of this bill.
Representative Lee?
I don't understand what the problem is.
So, okay, so you're sentenced to.
No, I understand your explanation
Yeah.
of that. I don't understand why that's a problem to have a separate parole and probation process.
Well, you're having two different bodies determine a punishment for the same conduct. That could be two different punishments also.
Okay.
Okay, then, I mean, if you
One-
didn't think it
one
was.
is parole, one is probation. They're separate things.
So let's say the judge says, well, I think you need to go back to jail. You're gonna go back a year, but parole says, well, actually, I think you need to do community service. So they're going back to jail for the year and then they're getting out and doing their community service for the exact same thing. And then we saw that as a redundancy, and you would be having two different bodies look at the exact same conduct and punishing them. But if that's what this was meant to do, then I'm not, that's totally your call.
I mean, two courts can interact on the sentencing of a person and it happens all the time. I don't understand why the parole board can't also work hand in glove with a court that's going through the probation process.
I don't think there's anything in this bill that would say, I mean, it sounds like this parole hearing is separate from the court. Now, will they talk? I don't know how that works. That may be a question for the Jewish branch, what communication would be like, but you do have two separate proceedings for the same conduct. And different disciplines, I guess, could be.
Representative Sinclair?
Thank you, Madam Chair. I don't disagree at all with what Attorney Burns is highlighting as a potential difficulty, and yet the having of two different spheres and two different mechanisms for evaluating the exact same alleged conduct is something we have in current law. If you look at the suspension mechanisms under the Secretary of State for an allegation of OUI, there's also a parallel but different criminal process that looks at the exact same alleged conduct. So it's not like we haven't created this same challenge before and either gotten over it or not gotten over it, depending on your perspective.
Additional questions, committee members? Yes, Representative Caruso.
So, I'm learning and I'm trying to get perspective and I'm listening to the attorneys in the room. It seems though what you're explaining with probation is very in sentencing structure with the sentence to 10, all but 5, and then it seems that is very similar to what's being proposed, kind of in terms of shortening the sentence. The judge can look at the facts of the case and all of the conditions similar to what this board would be doing. But the judge is already doing that and deciding on whether or not, how the length of the sentence. So it seems like the same effect.
I mean, I do think there's a difference with parole as the judges at sentencing, they're judging the person at that moment for what the Huey analysis tells us, what the judges have to take into consideration. And I think what parole gets at is what the person has done in custody of why they would get out. So they're seeing a different person. So I do think there's policy reasons, perspectives that they are different than what the judge sees.
I see.
But if you look at the third prong again of the Huey analysis, it's supposed to be to help the person, and I should say that protects public safety, but part of it is like they have to do stuff. They have to maybe have substance abuse counseling, go to domestic violence intervention programs. And then obviously there's time hanging over the head. So there's supposed to be incentive for them to do well in the community. So they're not back.
Right, and this, can I ask another question?
You may.
Please. And similarly, when it comes to that point where if it's the 5-year point where it was all but 5, say in a 10-year sentence, they'd have to, is there still a time where they have to kind of qualify to continue with that? Like if their behavior wasn't good, they don't get that?
No, your sentence is your sentence. So unless you do something during those 5 years, which I'm saying, then we file a probation revocation motion, which will add, it doesn't mean they'll get the extra 5 years. They could get 2 years, whatever the judge says it is. And then when they're out and serving their unsuspended portion, then they could, if they get in trouble, they could go back.
Thank you.
Committee members, let's take a caucus break and let's return at 4 o'clock sharp. I know that it's that doesn't give us a lot of time to converse, but I do feel like we need to check in with each other at that time. Thank you, everyone, for returning to the horseshoe. We're going to resume our work session on LD 1941. And I would like to ask if any committee member feels that they need any additional information from those present in the committee room before we move on to committee discussion and a vote. Yes, Representative Caruso.
I would appreciate hearing from the Department of Corrections, actually. They've been here, sitting here.
Yes.
Jill is.
Yes,
fine,
please join us,
unless
Jill O'Brien.
She wanted to.
Thank you. You go ahead with your question.
Thank you. Thank you. You need to identify yourself.
Good afternoon, Senator Carney, Representative Kuhn, and distinguished members of the committee. My name is Jill O'Brien, and I'm the Director of Government Affairs for the Maine Department of Corrections.
Great, thank you. I remember us hearing testimony in the past, and maybe at the hearing, about other programs that kind of do the same sort of thing, in terms of reducing sentencing, and I had a brief discussion with Shire Burns about this, but I was wondering if you could explain about and thinking about if there's conflicts with the probation and parole and what the systems that are in place right now to reduce time served and how you think that would work if this were to become law. I know it's a lot of questions, just take it as you.
Thank you, Representative. So since parole was abolished in 1976, there are three mechanisms that accomplish similar results. You've heard me talk about supervised community confinement, which is by statute. And under that program, residents can, in the last 30 months of their sentence, so 2.5 years, spend that time in the community, supervised by our probation department. Judges have been giving split sentences, which Attorney Burns discussed, some period of incarceration, some period of probation, with that time, the suspended prison sentence being the consequence of violating that probation, and good time laws. So the good time that prison residents earn depends on which criminal code they were sentenced under. It varies in the number of days one can earn, but it is not uncommon that a resident could earn 10 days per month of good time. So Representative Lee suggested not factoring in good time here for the determination of what your half-time date would be for parole eligibility. But I think a good example to consider, putting aside the question of a probation revocation hearing and a parole revocation hearing happening and which one would go first, let's take the example of someone who got a 24-year definite determinate sentence, 24 years in prison. So under the parole bill, they would be eligible for parole at 12 years, the halfway point. If they're earning good time under the code that gives them 10 days a month and they manage to comply with the requirements and earn the good time, they would be serving, so they get 1/3 of the time off. So out of 24 years, they would get 8 years off and be serving 16 years in prison. They would be eligible for SECP at 14.5 of those 16 years. So you've got parole eligibility at 12 years versus SECP eligibility at 14.5. And it's the department's position that that 2.5-year difference does not justify a completely new parole board when we already have one. And when we have a supervised community confinement program that's helped over 600 people obtain those last 30 months, 2 years to 30 months, depending on when you apply, in the community supervised by probation. I've also talked in the past about the cost of additional probation officers to monitor these folks. I think the executive director that Representative Lee has proposed is going to need staff and a salary. The existing board of parole is paid by statute, so I would assume that the new parole board would also be. There's still the question of the probation and parole existing simultaneously. So I envision a situation where the parole revocation goes first because the timelines in this bill are very fast. And in fact, they require the Department of Corrections to get every piece of paper about an applicant to the board and to that person within, I think it's 30 days. which will be a very tall order if, given that victim information will have to be redacted, information about current investigations would have to be redacted. Putting aside that heavy lift, a parole revocation proceeding happens potentially without a lawyer, and then a probation revocation proceeding happens with a lawyer. Do all of the documents from the parole revocation proceeding automatically go into the probation one? And would the applicant even want that to happen? There are a lot of mechanical issues here in what is a very complicated bill that already overlaps a fairly complicated sentencing scheme. Did I answer your question, Representative?
Yes.
If you have a follow-up, please use your microphone.
Yes, so sorry, you were, in your example, I don't think my notes were that great. In your example, the 24 years, the parole would cut it down to 12 years if this were to become law. But currently, the good time could take off a third of that, which is 8 years, bringing it to 16 years. And then you said the SCCP program would kick in at 30 months.
You can apply it up to 30 months before the end of your sentence.
Before the end of the sentence. So that would bring it down to 14 and a half years. So we're talking about that 2.5 year difference between what we have now and what could be. What was the third? You said there are 3 mechanisms that are in place right now.
Supervised community confinement program, the good time laws, and the judge's use of split sentences, probation and period of no
Okay.
probation.
Thank you. I didn't have my notes carefully. Thank you.
Representative Lee?
Quick reminder that we got rid of the good time as part of the calculation as one of the amendments that we're making to the bill.
Yeah.
Yes.
Thank you, Representative Lee. I didn't have, that wasn't part of the parole. The parole in this example just cut it down to 12 years. So I think you weren't here at the time, but she was just saying, let's say we had an example of a 24-year sentence. And she was comparing what we have now, what it could look like, and that would bring it down to 14 and a half years versus what this law would do, which would bring it down to 12 years. So good time was not included in the parole example, in the parole version.
Yes.
Go ahead, Representative Lee.
In that example, nor are any of the other requirements of someone to be eligible for parole or the ability to get parole based on the factors from the parole board.
Everything. I allowed it.
Can you turn your microphone on and repeat yourself?
Yes, I think that was the best case scenario with the parole that they would qualify with that 12. Yeah.
Other questions for Jill O'Brien, Representative Sinclair?
Thank you, Madam Chair. Attorney O'Brien, is there any version of a parole bill that the department would support, or is DOC's position that everything is fine as it is and we should just skip over this entire policy area?
I haven't seen a parole bill that I think the department would support. I think that the population of 2,000 individuals in our custody, for that population, supervised community confinement is working well. They know the process, they don't need a lawyer, and they can create plans, they can get feedback on where the plan falls short. The people making the SCCP decisions are their unit team who've known them for several months to several years, and where the parole board would not. So to succinctly answer your question, it would have to be a very different parole bill.
Representative O'Halloran?
Thank you. I have 2 questions. The first one's easy. The difference in your scenario of, just so it's clear, the 12 years versus 14 and a half, that additional 2.5 years is basically under supervised custody currently, correct?
Let me back up because I spoke too fast. My example was someone getting a 24-year straight sentence. And let's assume they're sentenced under the code where they get 10 days of good time per month And let's assume that their behavior is such that they earn all of the good time they're eligible for. So they would get 10 out of 30 days per month, which is a third. So of 24 years, a third would be shaved off. So they'd be serving 16 years. They would be eligible for supervised community confinement to apply when they're sent 30 months, the last 30 months. So 16 years minus 30 months is 14 and a half. That's when they're eligible. And of course, they'd have to be approved. Whereas under the parole scheme, that person would be eligible for a parole application at 12, which is half of 24. So there is a difference, 2.5 years of potentially sooner release. But the expense here is very large, and it is a whole new system in addition to the existing parole board and the existing supervised community confinement program. Does that answer your question, Representative?
That is, and then my main
Go ahead.
question, thank you, is based on evidence that we've had previously or other states that do parole compared to what we have right now for probation, do you find that it is more successful of having people start out in a supervised type community where they are gaining confidence, learning good behaviors, good patterns, and things like that versus somebody that is released on parole and they're going right back to the same environment that they came from with all the same triggers or bad influences and things like that without learning how to get out into society and work and hold a job and, you know, meet a new circle of influences? Is there any evidence that shows that what we currently have is a more successful system?
Well, I think what parole is envisioning is supervision in the community by probation officers, just like if you were on probation. Does that make sense? So where you're living and your friends will be the same under parole or probation. That said, there's much greater success with probation than with just a straight sentence. Like you get out of prison and no, there is no probation after that. Does that make sense? Thank you.
Other questions, Representative Kuhn?
Thank you. You raised the question of the administrative costs of compliance, and I just wondered if you had considered the difference in cost of releasing someone who doesn't need to be incarcerated substantially earlier. I mean, does that sort of net out that expense?
So I think in the short term, additional staff will be needed in the probation department. Whether eventually there would be a lower prison population that could merit savings, those won't line up in time exactly, I think is the sort of balance sheet issue the department sees.
Representative Lee?
Thank you. I'm trying to understand one of the answers that you gave earlier, and I want to make sure that we're on the same page as to the process. You said that the department would have to turn over every piece of paper it has on the person who's applying for parole. Are you referring to the mandatory discovery provision?
Yes.
So as I read that, and I didn't draft this part, but I was fine with it because what it seems to indicate to me is the department would be responding to the application, and the documents that they would need to provide to the prisoner are simply those documents that they're providing to the parole board. And so to me, that's not every piece of paper on the prisoner. So it's page 5, 5825, subsection 3.
And at one point, this has changed significantly. Can you point me to where the department submits material to the board? If that is still in there?
The board would have an opportunity to respond to the parole application. And it would be those documents that it would be giving to the prisoner.
I've read this today quickly. What I think the board will want is a complete picture of the resident applying. So I think it's a bit unclear the scope of what will be provided or requested. do you envision, if we envision the board having discretion to say what they want from the department, it could be large, it could be small. And so if, when that is sorted, the task could be large or small. Does that answer your question?
I think so. I was understanding you just say that they had to go on some sort of like expedition of finding every piece of paper that they had on that prisoner, when the intention is that they simply have to provide a copy of whatever they provide the board to the prisoner as well.
Understood. If the board wants a vast review, it could be vast.
Representative Caruso?
Sorry, I'm not an attorney and I'm listening to attorneys talk. Wouldn't they want wouldn't the board, if they're going to review whether or not to approve this application, wouldn't they want all the documentation on the individual to make a decision? Would they? Yes. If you're
Who
gonna
is
make a
that question
decision-
directed to?
The people who are having the conversation.
So you want them
So-
each to answer, okay?
Yeah.
I guess from my perspective, the parole board's gonna want stuff dealing with the factors, right? And so they can request those things from the department. The department would provide those things. I don't know if that's every piece of paper that they have on the person who's applying, but it's, you know, from my experience, it's not very effective to just dump a bunch of paper. You would want to have a meaningful response to the application, and that would involve the stuff that's actually important. Yeah.
Jill O'Brien, did you have anything that you wanted to add in response to Representative Caruso's question?
Thank you, Madam Chair. I think, for example, the factor of whether the applicant has demonstrated good behavior and significant efforts to rehabilitate would reasonably lead the board to ask for 3 years of records, which is a significant lift when, well, that I can see them. I think it's unclear from the bill whether DOC decides how to respond to the application or the board makes the request. But I can see a significant period of time records being relevant to the factors.
Yes, and then Representative Sinclair's been waiting, so if you can just do one quick follow-up.
Aren't those documents that are presently considered when making decisions on the release programs that DOC has? Don't you consider all of that information already?
I do definitely the department considers disciplinary history in deciding SECP applications, but it is a relatively small slice when they're doing a community investigation. So SECP involves analyzing a plan, going out, actually an on-site visit to the proposed residence to ensure it's safe, clean, adequate, polling community contacts, the district attorney, potentially others in the community who may have an opinion on the release of the person. So it is a factor, but and their documents we definitely have. We don't have to redact them for ourselves or have concerns about victim or third-party informant information leaving the department when we're analyzing them.
Representative Sinclair?
Thank you, Madam Chair. I, excuse me, was going to start with the observation that Representative Lee just made and that I think has been agreed by the department that that the stuff's already being looked at. But I was also going to add that if this is envisioned as an adversarial process, then the board can rely on each of the two parties to present the material that each party thinks is germane to the board's determination, meaning it's not an extra lift unless one or the other or both of the parties decide that it's a heavier lift. And in the event it's not an adversarial proceeding, which I would imagine is the rarity, but certainly may happen, then the board's decision is going to be pretty simple if they all agree that, yeah, this is an application that ought to be granted. I guess to sum that up in fewer words, it sounds like the the department would be providing that information and only that information that it thought the board needed to have.
Representative Sinclair, I don't see the department having a representative there in an adversarial process. We execute sentences that judges make. We don't advocate for a longer sentence or a shorter sentence. We review SDCP applications and appropriateness of that program, but we wouldn't envision an AAG for the department being there opposing parole in any fashion.
Thank you. I'm sorry if what I said suggested that to you. I meant adversarial from the point of providing materials to the board. I certainly didn't believe that there was going to be an attorney for the state present there arguing in the opposite.
Thank you.
Any other questions for, excuse me, for Jill O'Brien? Thank you.
Thank you very much.
So I have an observation that I'm going to toss out, which is that I personally am much more interested in something that's prospective. And I feel like I have a lot of questions about how prospective implementation would work. And I don't really want to ask them right now because I think our heads are all totally full with what retrospective application would look like. And I am very reluctant to push our work off, but I also wonder if we really do need a little more time to let this percolate a little bit and to get answers to those questions. So I'm not asking for a tabling motion. I'm just asking my colleagues for their thoughts. Representative Kuhn?
Thank you. I was just gonna say, I feel like we made a lot of progress today in understanding the issues. So I'm glad we've taken it this far, but I know I am also interested in further considering a prospective approach and would appreciate a little bit of time to think about that.
There's Representative Lee.
I don't have a position on the tabling motion because I'm gonna vote for this report. But I fully understand if folks want to think through some other issues if they have a different report. I wanted to, before we were to move the table, I'd like to express a few additional amendments that have come up in our discussions, just to make sure we all know what those are and I don't forget them
Okay.
for another work session.
Yeah, before you do, but I'll recognize you to do that. But does anybody else have any reflections on the suggestion that we take this up at another time? Representative Henderson?
Thank you, Madam Chair. I am ready to vote on the bill now. I won't be supporting the bill or any version of the amendment that I've seen thus far, but am willing to vote in favor of a table if there are those on the committee that want to give it further consideration.
Thank you for that courtesy. Yes, Senator Hagan?
You just stole all my thoughts.
Okay, so a couple of things. Is there anybody else who wants to reflect on tabling or no? It sounds like there's sentiment to support others who wish more time to think. Representative Crusoe?
Just to be clear on where I'm at, I appreciate all the work that's been done on this. It's a lot of time. I just don't think it's at a place where it's usable for the state, given the system that we already have in place and the conflicts that were just expressed, and the cost. So I just think it needs a lot more work before I can vote for it. So I would be voting against it, but I'm willing to let the committee do what they feel comfortable with.
Okay, anything else on this topic of wanting more time or being opposed to a little more time to think? No, okay. Representative Lee, can you articulate your changes to the yellow draft that was provided to the committee today?
Sure. There were the ones that Eli and I both had at the very beginning of the work session. I think he's got those. The additional ones, just to make sure that we have them, are on page 5. In that calculation of not less than 10 years and no less than half of the prison term being served. We wanted to add language that essentially excludes good time credits from that. In or on page 8. At the very bottom in other factors. It presently says it should look at least the following additional criteria in making its decision regarding the timing and conditions of release on parole. The timing of and conditions of release on should be deleted. I think there may be another place where that language exists in the bill.
I checked and I think you're right that it was deleted, but I will do another pass through.
Yeah. If it exists somewhere else, we'll also delete that language there. And then the final one is on page page 7. 5826 sub 1, such guidelines shall give due regard to the, and it should delete racial, it should be the bias inherent in parole assessments. And that's it.
Does anybody else need to share anything before we move to a tabling motion? Eli, do you have any questions for the committee at this time?
No questions. I know that there's been a request for in a different format in terms of colors and shading. I will work on that. Would it be beneficial to the committee, in addition to having that, having a clean copy that has taken out all of the strikeouts, and so it would look like a strike and replace if this is what the printed bill would look like without everything deleted?
That would be tremendously helpful.
Cool.
And committee members and to the bill sponsor, we're likely to have a very short turnaround time on this so that we don't lose all of the information that we just put into our brains. And with that, would somebody like to be recognized to move to table? Representative Sato.
Move to table.
Is there a second? Seconded by Representative Pugh. Let's do this by show of hands. All those in favor? And that is unanimous of those present. And so we'll close the work session on 1941. Thank you, everyone. Eli, do we have language review or anything this afternoon?
Not today, no.
Okay. So Representative Henderson, did you wish to be recognized?
Thank you, Madam Chair. I move we adjourn.
Is there a second? All those in favor?